the Google point maps that investigator Bryant's generated. I think the defense is going to contend that there's continuing witness issue. That I don't think there is. So that's kind of where we're at.
And Your Honor, the point there.
Oh, and y'all gonna have to go just repeat yourselves because we're not on the record yet. So I'm just, I want to, with that caveat.
Those
Yeah.
are the issues. And that's the group there.
Okay. And would you classify those as demonstratives?
Yes.
Okay. And then generally, Ms. Levinsky, the position is those should not go back.
They should not go back. A, because they're demonstratives, and B, because they've got writing on them.
Yeah, that's. I would say I'll double check my case law, but I lean towards your position there.
I believe none of the reports go back.
When you say reports, you'll have to be more specific for me.
DNA reports we entered.
It's not like they
Okay.
can ever
I
see
don't
them.
believe they go back. My question was, these
They're ready.
documents,
Yeah.
impatient jurors understand.
Well, no, they're timely at 10 o'clock.
These documents, Google location,
Okay.
do they constitute reports? Do they go back or not?
Again, and I'll put all this on the record and you can argue it fully, but I would say initially that that's raw data. That's just a document. And I think a document would go back.
Fair enough.
But we'll,
Happy
you know,
for it.
we'll lay it out. Here's a question for you, which, you know, we know that videos with audio don't go back and
Right.
jurors can ask to come watch it out here. Could a juror ask to come look at a demonstrative again in court? It was admitted in evidence as a demonstrative. We're saying it probably doesn't go back because I think that's the law. But would anything stop them from coming out and saying, we'd like to see demonstrative X and just look at it? Something to think about.
I would say that they would be allowed to visit because they were entered into evidence.
Anything else that you anticipate needing to discuss on the record?
I don't think so.
I
Do we have anything else?
don't think so.
Okay. All right. Y'all keep compiling your stack because we need to lay that out.
We need the indictment.
Indictment, charges, and the verdict form should be right there.
Judge, do you only send back one?
I can print more. I'm happy to print more.
The last.
Let's
trial
not send
I
that back.
did,
Do we send that back?
They seem to want single sets of jury charges proved. I suppose so that they could all be.
Do the numbers match up? Do those numbers match up with this?
It might make sense to at least.
Okay, sure.
An extra one or two.
We'll print out a few
Well, what
more.
do you want to do with this? Do you want to send that back to the jury or not?
These don't go back. These don't go back.
We don't just send this back to the jury.
I agree, 100%. 100%.
Your Honor,
I have no objections to that at all.
just to let the court know, exhibit 534, we've agreed, and that is an autopsy photo. We've agreed that that shows the victim nude on the scene. That doesn't need to go back to the jury.
Well, again, we're going to put all this.
Totally accurate.
We'll summarize this on the record shortly when y'all have finished your work. Nope, sorry. Thanks.
Right. This is in the go back.
Okay, right there.
All right.
Yeah. And what's this?
That's the one I
Oh,
said.
that.
Yes.
Sure.
So- 45.
Well, this doesn't matter.
So this goes to 545. Where this goes to 522, 545. That order.
Are we missing one?
That's 546.
Mm-mm.
So this is 522.
Oh, you know what? It might be 546.
What is it?
You know, that is 546. Was it labeled there? Yes.
Okay.
Yeah, just put 546. Just to get it. Okay, that's 546. Yeah, right. I didn't even, I don't know what that is. Yeah.
So what have you
16.
done with the autopsy photos?
16, 17, 18, 19, 20, 22. I don't know if-
Where's 21? Oh, no, that's not 21.
Okay, let's, okay, 21, I guess. 2, 3, 4, 5, that's another one.
Yeah.
Well, I'd keep that, I'd keep going.
Huh?
I'd hold it.
And that.
No, put that one right there.
That's
Yeah,
I mean, honestly,
I understand, it's 526. It's right after that.
Yeah, no, okay, this one you called it.
Security.
Small and stuff.
Yeah, okay. Yeah, you ain't that.
I know you can't talk to both.
Well, here, and, you know. I guess, one I want. You got rescheduled. Yeah, I did. I mean, well.
34 is one of those.
Okay.
I don't know where else.
What you have to do based on.
Yeah. And then it's, yeah.
Well, you'd be surprised.
Whatever you want. Whatever you want. If you, I will get it, but it's like.
I don't have.
Was it unpaid?
That's.
I use.
Actually, I don't.
Yeah.
Yeah.
Here, I need 521. I need 521 right here. By 500.
Okay.
Yeah.
So like, and even one would have.
It's yours. They can figure it out, but it's been read.
Your hands are bigger and stronger. And-
That's fine. There's 521.
Oh, where did you find that?
That was in a pile. I looked through it and I had it.
Your hands are bigger and stronger than
Or at
me.
least.
They're larger. I don't know about stronger. They're larger though.
I would hope so.
I mean, they're larger.
I would hope they are larger.
Yes, we recently.
I wear an extra large golf glove.
So it doesn't make a difference.
Legal argument.
Yeah.
I gotcha.
That's a lot.
As long as you're fine.
What do you want me to do? Oh, straighten them by number? Oh, yeah. Yeah, sure. So that one's, okay. Oh, you know what? You did it perfect. You did it perfect. Hold on a second. I got it.
Well, in the civil trials, you know, they always have iron like that.
Sure.
Yeah, I mean, that one's filed.
Yes, ma'am. You just give me a second. I'll have it done. Oh, that's okay. That's okay.
I think it's not, especially when it's bullet. I'm like.
I don't really want to get them so straight that I start bending.
Or like, I wanna. Just let's say, not distracted.
Yeah. And then, let me get.
What was 2 and 3? Those were,
Two was CAD.
okay, so I'm gonna pull that one out.
Average, like.
I'm gonna
CAD
pull,
is out.
yeah, I'm just gonna pull this out.
Oh. CAD is the.
Yeah, here's 2 and 3. We just stuck the slides in there.
The CAD and then.
I wasn't.
The one.
exporting it to, I mean,
I'm
always. Not counting.
Yeah.
I almost.
It's not-
Where is the photo?
Yeah, no, I know. I'm just saying, where is it?
Should be
This
there.
stays, so about 100.
No, because this.
Oh, God. Hey, here it is.
Oh, perfect.
Hey, I
Yep.
stole
Dang you. Dang it.
Different circumstances,
Yeah.
more to put on the record kind of thing.
So you want these on the, you want your exhibits on the bottom,
And you're talking.
putting them on the bottom,
This kind of font size and this
The
size
font size,
page
remember the
or.
font size I showed?
which is the charge.
It's a little.
They
I mean, but
should be at the
still.
top.
Yeah. But it
Diamond?
doesn't change it.
This is on probation.
And the bullet form on top. Okay.
It didn't change anything, because I changed my font from.
But if it's underlined, the new
These
violation.
are the exhibits
That doesn't
that don't go out.
And
You're right here.
look at
That-
them
that's
when-
the whole issue is-
It's
Yes, ma'am.
You call it door off.
How long?
Really? Exactly.
Yeah.
Interesting. So there are only certain fonts that are compatible with that.
Yeah, our organization, we have to have cover, we have to
Yeah.
have a certain font, and then certain pages.
Mhm.
Yeah, but it didn't change anything. So this is pretty good. Should I give it to them?
Yeah, I'm not giving you enough, please.
Just leave it up here for Judge so he can
Okay.
do what he wants with it.
Yeah, this is the.
Yeah, well, no, it's.
Are you guys sure?
Like,
Yes, I'm not.
read a picture.
Those are the ones
Thing
we-
that I have.
Okay, so you know.
Sometimes I get wrapped up.
Fair
Thing,
enough.
not your reminder to
One.
that. So, to me, a reminder. And then- Hey, like, I'm just kind of.
Oh, you know what? There is that one.
It's called pepper.
I won't.
Okay. And then, okay.
And the same thing applies with that soul.
Hey, we got-
The printout, and that's it.
You can't talk before now. She's second year, but.
But she's not really second year, she's rising third year.
I don't know why they, I thought that the two old reps that, I guess they changed.
No, I technically can for the bar. I said it's.
Is that right?
What?
Our office's
Could you help me with
policy.
that?
What do you want me to do?
No, no, no.
You get away with that? Those policies.
Yeah.
And the email saying saying.
Sure.
Okay.
You just tell me what you need.
Okay.
Yeah.
It's absolute.
Okay.
And talk to Luana.
Okay. All right, so she's just gonna report, so there's no further, okay. I'll waiver. Okay.
And that she said.
Mr. Jackson.
I won't tell them.
So that's the whole one.
Mr. Vinsky.
It's opposite whatever you guys are supposed to do.
Well, that's the main problem.
I know, that's. I obviously found out like the week before I started.
This way.
Yeah.
You might be working. I started doing that. I was so right here and I was like. Literally. Just not
Silver
even.
lining is that you get to come back.
Yeah.
I know it's true.
So
They
they
did
did
it
an email with.
Well, I've known quite a few people about the way. Okay.
Yes,
But spring I'm good.
You know, they.
yes, we have.
And I'm like, no, so what we gonna do?
You feel free to hire. I really don't want to have to go 3 hours away to send them. No, I can.
That's Nick was our intern
That's what I said.
last year.
I thought, I didn't want to say it.
Hired with our office.
So
That's nice.
Another attorney hired.
I wasn't really sure what your hiring
She
was like
also wants
because
that.
nobody's seen it.
I think
Yes.
It's their turnover.
help with that. I guess that was just you working on it, but it was really helpful, all of your,
What's that?
just all of your help with it, letting me know about certain things like that.
Oh,
I appreciate
I mean, I plan to be in Atlanta.
we
You
tend
see
to
how
hire.
work close?
it. I'm gonna know.
I think you should everybody hire what they get, whatever they let you do, but yeah. So I'll take whatever.
We hire really.
Members of the gallery, if you are not an attorney on the front row, please turn your cell phones off or on vibrate.
Ready?
You have to step out. All the people required to allow their cell phones.
Yeah. It'll take 5-10 minutes. All right, we're back on the record with 20 SC 177243, State versus James Jones. All the parties are present. The jury has all arrived, and they're indicating they're ready to begin deliberations. So we need to discuss what is going back and what is not. As I understand it, the parties have been conferring. We've got a stack of exhibits. Is that right?
That is correct, Your Honor.
Okay. And there'd been a request by defense to print off some more copies of the charge. So I've got 5 more copies. So if someone could please include that with the others. And let's start with the, we'll just have the state summarize what exhibits are currently in the stack. And then if there are challenges, we'll go through it and take them out depending on how I have to rule.
Yes, Your Honor. There are some, to summarize, Your Honor, there are crime scene photos. There are photos of the autopsy, crime scene photos from the scene, and then there are also photos of different locations of a vehicle and a storage unit. There is a CAD report, 911 report on a compact disc. There is,
And when I know these are things you're including in the stack?
yes.
Okay.
Yes, and
Well, defense counsel is shaking her head.
That report has not been included.
I don't know, y'all. I don't look at the stack. Y'all have had an hour to look at this. Tell me what's in, what's out.
That
I had it
report
in.
was not included.
That was the first one you did. Yeah, reported on that call.
the 911 call was introduced, Your Honor. That would be Exhibit 3. Exhibit 2 will go ahead and, I don't know if I thought we introduced that, but I don't
Yes,
have that.
it
It was introduced. We're talking about what is on the stack to go into the jury room.
Yes. It's not in the stack to go to the jury.
And that's what my question was. What is in the stack to go to the jury room?
The exhibits, well, first of all, the indictment, jury charges, verdict form, the pictures, exhibits from what I had previously described, and that would be what we intend to send back to the jury room. And also, there are I believe two defendants' exhibits of Google notations, I believe. And I think that's correct, right? That's what we intend to send back to the jury.
All right. So is there, I mean, I would say you could just summarize it by exhibit so we know what went in, what went out. But if you want to do it this way and there's no objection from counsel, we'll just hand it to the jury. That's fine.
And we've looked through them and we're in agreement the two of us are in agreement, which were introduced, and those are all in the stack, Your Honor.
Okay. I'll just turn it over. Ms. Levinsky, anything you want to add for the record in terms of what's on this stack of exhibits, which,
No objections, Your Honor.
okay. Anything else you want to put on the record to perfect it of what's going back and what's not?
Your Honor, I believe we've discussed what goes back and what doesn't go back. Continuing witness does not go back. We have taken out anything we believe constitutes continuing witness.
All right. There being no dispute between the parties.
Your Honor, there is on 506, on Exhibit 506, which is the martyr surveillance video. Those are those surveillance videos that are silent. And I think the court referenced them yesterday. And I think it's defense counsel's argument that it's continuing witness. I'm going to cite the state, or the state versus, or Muse versus state, and that is 316 GA 639, and that is, stands for the proposition that surveillance videos are not subject to the continuing witness rule, so that the court can do the procedure that the court scrubbed laptop.
This 506, the just the raw footage itself. It doesn't have title overlays. Okay.
Yes.
So for now, we can include it on the stack. They have no ability to play it. So until they ask us, we'll readdress it. I'd mentioned that yesterday, but we're not there yet.
If it's the raw footage without the state's additions, that's okay, Your Honor. My objection was to the state's additions yesterday.
And I don't recall offhand if that was eventually tendered as a different exhibit or not, but
It was not tendered ultimately as an exhibit.
all right. So then 506 itself, just being the raw footage, that would be included in the stack as we're calling it. They have no ability to play it. So until they ask us to do that, we'll address it. As I'd mentioned yesterday, we have a scrubbed laptop and they could review that as many times as they want in the jury room. But I want to, for now, allow them to start their deliberations with what they have, since they've been here for a little while.
And I need to correct, it's actually 507 is the exhibit number. 507, that is the difference.
All right. And
What surveillance is that?
That is from the house.
So it's the house surveillance you're giving them, not the monitor surveillance.
I think they should be allowed to have both, Your Honor, 506 and 507.
506 is surveillance video from the house. 507 is MARTA footage. Both of these are solely the videos themselves. They're not any title overlays or any editing. It's just the raw data itself. Is that right?
That is correct.
Okay. Ms. Levinsky. Okay. All right. So is there anything else that you're asking me to rule on of what should come in, what should stay out, or anything like that? Or otherwise, we're just going to say generally this stack of exhibits has been agreed to by the parties.
I understand what you're saying.
Wow,
Mr. Wilson, anything else?
I don't believe so, Your Honor.
Ms. Levinsky, anything else?
I don't believe so. There's some document.
I mean, just give it to me. It'll take 2 seconds.
What is the document in here?
Let me look at it. Can we hold on 506 for now? To send it back to
That's
the
fine.
jury?
We'll hold back
And-
506. Let's send back everything we already have, which parties have agreed to. So Deputy Scott, if you would be so kind. We are sending back the agreed upon exhibits right there, and you can go ahead and give that to them and tell them they can begin their deliberations. That's right.
This is what
Yeah, that's what that does.
I was just talking about deleting it. It's on delete.
All right.
You don't need.
It should be on top, right? Or under the indictment.
Don't go back.
Yeah,
If you could put the verdict form on top, so they don't lose that.
I'm showing you.
It's not going back. Going back.
Just listen.
It's not going back. I'm not letting it. Judge, there are notes on some of the videos. They are not going back.
When you say
State.
notes,
There we go. It's gone.
That's the raw camera footage. That's all it is. We're getting rid of this notes.
I was showing you I was deleting it. So that's the.
hey, good morning.
It's good seeing. I was downstairs.
What do you have today?
Sure. That those notes
Oh,
aren't going
okay.
back.
I didn't see it.
Okay.
News to
Your
me.
Honor, I
You might check
think
with
in
Ms.
the
Bordas.
Of safety, it would be better for this not to go back.
Yeah, check with, well, don't go back there. We got a jury. Oh, okay. You can sit there. That's fine. That's fine. I'll tell Ms. Bordas. Yeah. All right. So there's some disagreement between the parties on which exhibit.
That would be 506, Your Honor.
506 is the house surveillance footage,
Yes.
and it was silent as far as I could tell. And so, what is the contention here?
There were notes. They had notes actually at the bottom of the video footage.
Is that
Those have been
accurate?
deleted. And the only thing on it is the raw video, and certainly
So when you say they've been deleted, what do you mean? Like the exhibit you tendered is now different? You've changed it?
Well, I think it'd be best to show, Your Honor, the, what we did delete. Within that exhibit, there was another file that had the DVR time separated out in minutes and seconds. So as we work our way through the 4 or 5 files from the cameras, it assisted with playing it. I believe it was placed on there for convenience during the trial. I realized that was on there. So my intent was to ensure that part did not go back with the jury, so that if they had free access to it, they wouldn't also have, our notes for minutes and seconds. So that was my intent. And I showed Miss Lubinsky that. I told her what I was planning on doing. And then I showed her what the process was and what the result was. So,
Okay, so just so to drill down, 506 is the house surveillance footage. It was tendered as admitted. It consists of multiple files. Some of these files are just the raw data. One of the files, I guess you would classify more as demonstrative because there'd been some additional things done to it.
no. There are, I guess if I'm saying there are 5 files, then I'm just guessing 5 or 6 camera files. Just click on it and it plays the surveillance video. There's one PDF that is a photo, cell phone looks like, of a handwritten notes with, conversions from this DVD to go to
Sure.
2 minutes and 30 seconds. So that's why I knew it was improper to go back. And when I saw
You've
that,
removed that.
I
Okay.
realized that, and I removed it while I was showing Miss Lubinsky.
And would we also say, as a matter of the record itself, that is not a part of 506?
As a matter of the record, was never intended to be a part of what would be tendered in evidence.
All right, so we're all clear now on what is 506 and what it contains, Ms. Lubinsky.
Video footage from the house.
And so in the format that Mr. Fawcett has described, are we all now on the same page? And now that this is just the footage itself, it would be allowed to go back?
Your Honor, my preference would be that if the jurors want to watch, they come out here.
All right. We'll take that up as soon as if I hear some direction from them, how that's going to work. But just so we know what's in and what's out and what should be back and what should not be back, I think this would fall under the category of a surveillance tape that does not have audio, that it can be in the back. As I pointed out, they have no ability to play this right now, so it really makes it meaningless right now. Should that change and they start requesting to be able to watch it, I think I would likely be more inclined, instead of having to sit here and curate how they're watching the surveillance footage, is to give them the ability to do that. And to that end, I'll probably just proactively go ahead and show you the laptop that we would plan to give them. We're actually in the process of installing on the wall a large TV and technological capabilities for them to be able to do this for every trial going forward. And it'll be for next week. We just won't have it in time for this week. So with that, sure.
If that happens, could we queue up a video for them out here so that we're making sure they're not looking at Word files or PDFs or something that may be violative of continuing witness that may or may not be on the flash drive?
We should know what's on the flash drive.
I understand that, but even if something's deleted off the flash drive doesn't mean that I'm just not sure what the state has done, and we haven't exactly seen it. So I just, if we can queue up the video that they want to watch for them out here and then give them the laptop so they can just press play and play the video, I think that would be preferable.
What I would say 506, the revised 506 that they have, is that what's in front of me here is a flash drive?
Yes, sir.
Okay. Why don't we give that to defense counsel? Take a look through it, see what's on there, if it's all in compliance, and then if they start asking about it, then we'll start talking about giving them the laptop so they can review it. And so in the meantime, we're going to get you that laptop so you can make sure you're in agreement with it. Anything else we need before we hold in place and await further direction from the jury on behalf of the state?
I believe so, Your Honor.
All right. Anything else on behalf of the defense?
No.
All right, then we're off the record. Mr. Fortis, did we have Mr. Sims and Mr. Fortis on the calendar? Okay. Is there supplemental? Just add on. You got any others that are add-ons? Oh, Logan's here today too. Is Kamani King coming? Okay. You knew it. I didn't know it. Yeah. All right, and I'll just touch in on this one. We had a 10 o'clock revocation calendar. I know the parties are probably still discussing or have some issues, but I just want to run through it and see where we are. We had position one, Quantavious Hinton, with Mr. Melnick. I saw him a bit earlier. I don't know where he went. Okay. And so I'll check in with him again on that. Position two, Leroy Goober.
I spoke with Mr. Blueberry yesterday, and it seems like there's been a kind of like a consent. The probation had him sign and just want him to report. They were good. And I think I informed Ms. Rutland of what they in probation, what my
Okay.
client said. And I think they only wanted 30 days and he's done 57. Is that kind of situation.
Okay, so there's a consent order to be presented. Anything else, Ms. Rutland, to note?
No.
All right, so for the failure to report, it'd be, I think probation would present that order, and it would be 30 days to serve, credit for the time served, and continue on probation from there. Okay, that'll take care of Mr. Goober. We had position three, Albert Jackson.
Present. And I have a counter offer I just got, but I think we're probably gonna have to have here.
All right, and is this, I noted there's a PI case. Is that the basis for the revocation?
Yes.
All right, so I'll wait to hear from y'all for the direction if we're just going to set this for a formal hearing and where we go from there, okay? We had Mr. Milner.
Is mine and, I talked to him and I tried to kind of negotiate, but we may have to have two here.
All right, again, I'll just wait for your final announcement on that one. And then we had Mr. Hardiman.
Mr. Hardiman was reset to June 26th.
26th or the 27th?
Oh, I'm sorry.
26th, okay.
First offender revocation.
Well, yeah, and I do remember his case, and I think now he's got 3 PI cases. So I guess let's just pick one perhaps and go one at a time if we need to. I think the most recent was a possession of a firearm and an aggravated assault. And we'll set that for a hearing and go from there.
Will that hearing be, get some?
Sounds like 6:26,
Okay.
and you can just keep in touch if you think there's some complications that arise. But yeah, I would suggest perhaps in the interest of time, I don't know if we need to do all 3 PI cases at once. And we can do them one at a time and see where that takes us. Yeah.
Are you talking about voting them separately on all? Just 3?
Well, no, I mean, I just don't know I mean, the state could choose their strongest. We see if they meet their burden of proof. If they don't, we'll move on to the next one. And if they do meet their burden of proof, then I don't know if they would have the need to present the other 2.
That second part is
Yeah.
what I'm thinking about, because if he gets revoked on one and then gets sent to prison, we have to bring him back for the other 2.
Right.
Go back and forth.
So I guess something to consider, Ms. Rutland.
Understood.
Anyhow, all right. We were going back to number 1, which is Mr. Hinton with Mr. Melnick. Were we letting Carnistel handle that?
He did.
We were gonna let him, just trying to go on, but the defendant may not take the plea, if she could not take the plea, so it did.
Carnistel don't want to handle that?
Why can't it be handled in trials?
No, Mr. Melnick said that card seller sent in the back if the defendant does not take the plea, and we will have revocation.
Okay. Okay. So we're just waiting for an announcement from Mr. Melnick here,
Well, I don't think we're gonna take that plea, so we're gonna reschedule.
set for a hearing.
If we have time next week or the 26th.
Okay. All right. And then for our add-ons, Mr. Force, were you able to confer with and get in touch with Roderick Bridges and all this? It turns out it looks like Ms. Vortis had some of these emails you were referring to. I never saw them.
Right.
Okay. All right. Well, y'all send it my way and we'll take care of it. Is he here? Do you see him?
I had him on the phone.
Yeah. Well, he's not in custody, is he?
Yes.
Oh, he is in custody. Excuse me. Okay.
Yeah, he did.
Okay. Did you need to meet with him or you already figured it out? Okay. All right. Then I'll just wait the consent order.
How about both parties?
Okay.
Did you? Oh, let me check.
I think I drafted one and I sent it over.
All right. And then I understand we also have as an add-on Mr. Logan and we got Mr. King here.
Yeah, I'm gonna.
Who's on that one now? All right. New point of contact for you, Mr. King. Mr. Pennington in the front row. Y'all want to chat before you make an announcement?
Yeah, sure, please.
All right. Just let me know when you're ready.
Okay.
Do you know the background of this one? This has got a bit of a
I know some of the background.
story.
I talked to the probation officer. He'll be available by Zoom. We need to have some.
Sorry, I didn't know there was I don't know who that probation officer is. It's been a woman the entire time, but talk to the state. And then I would hope that we can have a pre-trial to see how the court feels about this whole thing.
Okay, we'll do that.
I don't think we'll need that long.
I hope not. I hope not.
Thank you, Judge.
All right, anything else need to be addressed or be heard? I think we are in a holding pattern then.
Hey.
Whoa, 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 no. We have a
I
jury.
didn't know you was a trial judge.
All right. All right. Deputy Scott, if you could let the jury know, I guess we're going with Jason's Deli at around 11:30 to 12.
Yeah.
Just more work. All right. We're in recess, so if you need to take the defendant back, you can. Okay, thank you.
You got Sam Smith?
I do.
That's good. Jackson wants me.
Okay.
Can we do 3 months? Oh, here, but he'll come back and go to prison, go into the jail, if you say yes. I know he just got on probation, it looked like in September of last year. He says he's going to be supposed to, he has a mind break. He was, well, he picked up his drugs, he had one of those, how the gas station had those gambling games.
Oh, yeah, yeah.
And he was sitting there and some dude dropped it. He saw what it was and he picked it up and when the police came, he stopped him. I mean, he doesn't have any real defense because I said, even if the dude dropped it, you should have this. But he picked it up.
Mm-hmm.
Cause they gonna assume it's his.
You ask him about 6 months.
See, his mama's got Alzheimer's and he tries to take care of it. About 4.
Let me ask.
Okay, I mean,
Okay.
all we can do is ask.
Okay,
All
I'll
I can do is
ask.
ask you, and all you can do.
Yeah.
is ask
For a
somebody
while, I'll
else.
be asking.
I'm okay,
supervisor. Okay.
I'm okay with that. I
Okay.
still ask Vesta,
Okay.
and I'm 35 years in the game.
This is my second year for criminal.
Really? Okay, I love it. Obviously, 35 years,
right.
you know.
Yeah.
My son is, he works for the conflict. My mama
Oh,
was the
wow.
first woman public defender in the
Wow.
state of Georgia.
That's
Black
awesome.
woman. So, you know, that's what we do. So I'm
Right.
all right, ask whoever
Okay.
you
Okay.
want.
Thank you.
You gotta make any changes to it?
I just put my name on it.
I mean, what do you think? Otherwise, it reads pretty well.
Yeah.
How do you like it? Here.
Not bad. Yeah. It's going well.
That downstairs stuff is full of birds.
What happened to you? Oh, yeah. Yeah, for sure.
It's just too much.
Yeah. Yeah, I do. Right. What I wanted.
Anybody here for Sims? Okay, I didn't see back there. He may not come out because we're gonna just submit the order, but right after the judge signs the order, assuming he will, and I believe he will, he should be released either today or monitor before he gets released. Okay? What's that? Okay. So I don't think he's coming out. Okay. You're welcome. I'll be in touch, okay? But just call me when he gets out. Okay.
Have a good day.
You as well. Anything from me? Not coming out. We're just gonna submit the order, because that's what the judge said to do. And then, assuming he just signs off on it, then they'll file it. And then once it posts, I think you just have to get him an ankle monitor. So you can probably, no, because it's just a reinstatement.
I'm sorry, no bond.
No, there's no bond because it's a probation violation. It's just reinstated.
Okay.
All right.
I sent it.
All right. Perfect.
Perfect.
Thank you. Have a
You're
great
welcome.
weekend, okay?
You too.
All right.
You're not sending it to me?
I just sent it.
Mhm. Don't get their copy before you release it all this side. Yeah,
You're gonna file it with all this stuff.
yeah, but I'm still giving you a signed copy. In case something happens again, like at the jail. Y'all have his booking number, man?
I don't think I put his booking number. Did you put his booking number on there?
Oh, no.
You handwrite it? Boy, how long did you stay down there? In non-complex,
I was-
2 months.
Yeah, I wasn't there long.
So it used to be like out of here. Used to be just like-
And one thing.
Okay, yes, I understand. So here's what happened. I incorrectly assumed that since there was trial going on, that the calendars would be moved. And then I saw that email from Terrence and I was like scrambling. So I know moving forward. Okay, that's good to know. Okay.
So it used to be like back in the day. They just turn and burn cases.
Yeah.
Except the more serious cases.
Right.
You're welcome.
Not complex.
But it's her fault. There were 71 cases on the calendar call. There should have been.
Right. That's insane.
Right. Just no one sounds like weed shit.
Right.
And I know your hands were tied.
Yeah, I'm always trying to go to a supervisor to get for folks to be like, let's focus on what we need to focus
Right.
on.
There's some jurisdictions that, depending on what it is, they just,
Yeah.
you know, unless you're like, you know, the 7 deadly or whatever. Were you in this trial?
No.
Commissioner? He didn't answer.
Maybe he's back. Okay.
This was a fun book. Please, go back.
If you get those squeezed. There's a little sugar and honey.
It's not. They have a silent video feed frame, that's one thing, this is just the sound, it's not even video.
Okay, I didn't even move back.
I was ready to move. I
Okay.
think they have a backup.
Okay, yes,
But I
so.
don't know that was actually entered though.
No.
Is there got a question or something, a verdict or something?
Oh, it's true.
It's a light.
Not provoking any more time.
Okay.
Well, we didn't say the balance. You didn't say nothing special conditions or anything.
Mr. Fawcett?
Okay, all right, thank you.
No.
Do you wanna,
Well, do you know if he will get fitted for the ankle monitor before he moves to jail?
oh, are you guys adding a new monitor?
Can you do that?
So, that's a special another,
I think this is supposed to be
how
training.
long?
2 years on house.
Free.
Oh. He's on.
Problem is, when I open this application, it doesn't play no video, it
That's
plays
what I
sound.
wanna double check. Okay, he just said.
But I believe it.
And the social.
And there's a still shot above it. It's just a JPEG.
Okay.
So. Yeah, you don't play the video.
Yes.
Yes.
So my question is. If this was the exhibit that was
What's
entered,
the condition?
was the training video actually entered that? Or not? Because we saw it in the demonstrative show. All these other ones are station cams. This is wow. Right. What program? Well, it is a program, it's not a file, it's not just a file, this is an application.
Church and
Medical work, yes, just.
Does he have curfew?
Okay. Okay. Just looking around there. So that is the issue that I think we're just doing it the old fashioned way. Although then there's a question because that video technically does have sound about continuing witness.
It's an application, it's not a file.
So yours plays the video. That laptop won't play the video, but that video has sound.
Okay, well, I mean, this is what, you know, I was 10 minutes. And, there's a laptop on. Yeah, I think she did say that the.
Did
train-
sound.
Yeah, I think she did say that the train had all your. So, perfectly fine with that. Yeah, okay.
Maybe got that. And the photo that's also.
And then-
The
lights on too. Well, the station videos that are on this drive are fine, but that folder for Fraser,
Yeah.
that one has a video with sound and a JPEG that's a still from that video.
So
This is
because,
the mod.
so because of the key,
All right.
all of the, I guess the thumb drive coming out, or have them come out to view it
Can we,
in court.
I'm fine with
Wait,
it, with
okay.
the latter for sure.
Let's just do that.
Yeah, I got y'all.
appreciate you.
Has anybody attended to the last?
Yeah.
I mean, about that. I think anybody-
Yes, ma'am.
They wanna get my hand talk about this.
He's telling us, he's not. Okay, yeah. But in a way around it.
Night, the only way around it is to change, completely change the chart.
Correct.
And I want to, like, everybody feels like, modify, but that doesn't change it, you can't modify it, I mean, it's just automatic. But I could file extraordinary motion, and then if everybody was, hey.
He signed up.
Yeah, just,
Yeah.
He's saying so transfer to Ohio, so it's just have been completed, so we don't have completed sex offender special election. So we just.
Excuse me.
She just gave you.
Those need to be filled out by the judge. Probation, that's the petition of Ohio. For the process. So here, you can just stay in Georgia.
that's probably food, I mean, yes.
Right. That's what you mean, like a shake. No, it's me. Yeah.
Yeah, I mean, it does.
That's what they don't want to work with because of that.
I understand. He is a whole new man. A few bits.
Okay, so we're still waiting.
Okay, and the other thing is that there's just a question.
Excuse me.
One of these days, we need.
Sims, what do you guys?
Not sexual. Stuff for.
I sent you the revocation order. I got that part, but what was the consent?
And I'll be
Motion to.
The consent order,
Right.
I think that's the one I sent you where we can.
Okay, you sent it already.
Yeah.
Okay, gosh.
Well, they just allowed them, you know, to take the special conditions.
Right, we should think.
Right, some of the states.
You follow them, they're right. Once you put, they be opposed to.
Yes, but I don't know that there's a right motion. I mean, this
I don't
point
know
has been
either.
over years, probably 80s.
Yeah, probably would.
But I mean,
I'm not sure how that is.
everybody agrees. But if they agrees, then we need different.
Yeah.
They can be here, right?
Yes.
Oh.
Not
Not supposed to.
Joya Rutland. Nice to meet you.
Do we just check every single one or is it something? Okay. Thank you.
But that's in addition to the applicant.
This is the one he gave.
There's one I just.
Oh, the one you gave.
Yeah, it was Mr. Benson. He has a whole packet. Yeah.
Something.
Do you have more paperwork for me regarding this matter?
Maybe.
I just probably, and what did she give you?
Attorney Seminole said each thing they would put some.
Yeah, is that?
Especially when that shit's.
I really know what that.
Yeah.
That is for.
Shabbat. Yes. Oh, yeah. So this is
Yes,
this
ma'am.
one, right? So this is what she means then.
And then.
Yeah. Okay. Computer use and poly. Okay. There's three separate.
These are the ones that got her.
There's two.
This is an additional one. And this is an additional.
Yeah.
Okay.
Yeah.
There's no heat. I just work. But when we first started, we had.
I didn't, I think I called.
Oh, I.
Yeah.
Okay.
Because if you have an update for me.
Yeah, that's why I was,
We'll,
yeah.
we'll bring this to the employees. Okay, thank you.
It's cold.
No, I'm talking to jail. Yeah.
Go over video files that we actually want present back. Or. Open around for different directors.
And which most.
So if we wanna
Yeah, so it's right.
make this another exhibit.
We can do process.
How do we do?
So that's what I don't like work. Yeah, I had to learn to do.
Add another exhibit to be closed.
Well, so,
This is what I get.
it'll be a court exhibit. Yeah, I don't know.
I think I'm. And see, I rewrote. Cause I felt. And then so if I learned something. It looks like this.
Yes.
And
Well, at the very least, one of the videos not used for that, you can't go back and the picture. So that's it. More videos, surveillance videos play fine. Those are mute. That's fine.
And so it's going to show us up on shows. So it's just.
No. I'll bring the stuff to
Is it A O? And this is those two. And this is a long I. So we'll write about that. And it comes down. Because they're that's hard, right? So I don't like how it's and then.
Yep.
Oh,
yeah. Wow. How was that?
It's been out.
That's what it meant.
Sure. Instead of. So much. Instead of. I think. Sure. Instead of. Oh. Oh, sure. Yeah.
Okay, I just wanted to know. I just wanted you to have it.
You guys can do that today.
Isn't it?
Terrence is good.
Yeah, he's been really helpful. Yes. Yes. He might have logged, it might be him. Let me see. Yes.
The only video with sound, yeah, and the photo. So those two things, I think, don't go back. And the other thing that I just want to mention is the stuff that I saw past case.
Yeah, okay,
So.
all right.
Hi. It's Joya.
That's my solution.
Hi. I was wondering if our victim could change his name on his Zoom to be let into the
I don't
Zoom.
know. Just because a clean thumb drive doesn't solve the stuff that's already.
I think I
listed.
No, as far as, as far as.
These
thank
drives
you.
are fine as long as you get rid of the brazier folder.
I don't want to modify that.
Okay, then we can copy the stuff from part of the clean one, but I don't know how we do that without. Exhibits, and I don't
You
know how we do
can't
that.
just run another exhibit because the evidence is.
Yeah. Okay.
All right, what do we got ready?
And that's pretty good.
Is Mitchell ready on the plea? But first we gotta take up some other stuff. If we could bring out the defendant. We were on courts 3, if I'm not mistaken.
Yeah.
Contains 2 items. It contains the video with the sound, and it contains a still from that video that is a JPEG that I would classify as demonstrative since it's part of the actual
Maybe.
video. So I would say that that still shouldn't go back for sure. And then there's another issue that I want to bring up with the court's proposed logistical solution to the jurors watching the videos on the court's laptop. I did.
Let's go in order though, because we interrupted the state here.
I'm sorry.
So, Mr. Wilson, what is your position on how we address this question?
Your Honor, I don't know if there's a, because I know the court wants to use the laptop to give them to play it. Normally, we would just play the portion that they want, and if there was sound on it, we would mute the sound. So they wouldn't hear the sound, which I think is appropriate because we didn't play any sound to them. I mean, the exhibit speaks for Honor.
I mean, the sound is immaterial. It's just a train sound. So again, I think we're getting in the weeds on something that has really no bearing on this case whatsoever. But if the parties insist on it, here we are.
I don't, Your Honor. I just want to advise the court.
I know,
fully.
and we're working through that.
Yeah.
So the point being is 506 has some files on it that have no sound, some video files that have no sound that are playable on the court's laptop, and one file that is not playable. Excuse me,
That's 507, Your Honor.
And one file that is not playable, but also has some ambient noise, essentially.
Yes.
All right.
I think that's accurate.
And your position is that?
Our position is that that is part of the exhibit and and that should go back to the jury room, Your Honor. I mean, I don't see that, like the court said, the sound is kind of extraneous. There's no conversations or anything like that on it between anybody that would be relevant to this case. There's just background noise, and then there would be the train announcer, and that's that sort of thing.
All right. Let me turn it over to you, Mr. Simenoff.
Yes. So as far as it going back with the jury, that'd be great if it worked on the laptop that we want to use, except that it doesn't. So they can't even view the actual footage on that laptop. So as far as that file is concerned, we have to play it out here. We don't have a choice. Sound or no sound. So I think that kind of resolves itself as far as the issue of bringing the jurors back out to watch that.
Well, yeah. All right. No.
Yeah, the other files are fine. The other files don't have any sound, don't have any issue playing on that laptop. I have a different issue with the laptop
All right. Let's talk about that.
that I wanted to bring up. And I don't think that the files from other trials are on that laptop. I think those have been deleted or were on external drives that are gone. But the way that Windows indexes things and catalogs things into like quick access lists inside panels and different folders and file explorer, those files are still listed in there. And there are folders that are still listed that I don't even believe are technically on the machine, but there are lists somewhere in that computer where if somebody were to click through could look at least those names. And that may potentially cause some confusion back there. If somebody's playing with the laptop and clicking through things and asking, well, what's this file? What's this folder that's labeled? There was one that was at a 52 that doesn't match anything in this trial. That's from a different case.
All right. Can you hand it to me?
That's something that may come up if the jurors aren't directed on how to actually use that equipment. If we send it back.
Like the champ, like those things listed, like they're named, but they don't go anywhere.
Right.
You try to.
I removed 2 folders from quick access that weren't opening or going anywhere. So, but the other stuff, I don't know.
Okay. So I saw some things on the quick access drive from the file explorer. I removed those. What else did you find on here?
That's it. I tried opening the files that weren't related to this case and it didn't open.
All
I
right.
just wanted to point that out to the court for the record.
Do you want to take another look at it and tell me if there's anything else on here that you think is objectionable? You can take it back to count table if you need to. All right. All right. So I've allowed both parties since I think the jury started deliberating at about 10:30 to take a look at the court's laptop. Am I hearing any other objections to this going back? My plan is to bring them out and instruct them, give them some instructions on how they should use this, specifically that it should solely be used to review media exhibits that we've provided them and for no other reason. I don't think they actually can use it for any other reason. I'll just give them that instruction anyway. I would also kind of tell them, just so they understand the process, there are certain exhibits that they're allowed to have and certain ones they are not. And so just to let them know that it's not because we forgot to give it to them, but there are only certain exhibits they can view. I would ask the state here on 507 for now, because we can't play that one video file on it. Do you have an additional external hard drive? We can duplicate it and take that one off.
I did bring a clean thumb drive just in case that would work best.
Okay, let's do that, where you're just having the videos that do play on this laptop and that have no sound. Those will be the ones we send back. I'll tell them there's another video that you can watch in the courtroom if you'd like to, but these are the only ones we can send back, and that'll address the MARTA video footage.
And then there's the photo as well, the JPEG, that's in that same folder that's a still from that video.
There's a still from the video. Well, let me first get the position of the state on that.
I mean, it's part of, it's just a snap video, Your Honor.
Yeah.
I mean, it's part of the video.
Right.
It's not a part of the video. Somebody has taken a still shot of the video. It's
Well, I guess the concern really there is, I think it would be perfectly admissible to take a still shot of a video. That wouldn't be a demonstrative to highlight parts of an exhibit. The problem here is that the exhibit was not tendered as having still shots. It was tendered as having video footage. There's been no testimony, no reference to how this still shot was made or taken. It's just got dumped into the record. And so I don't think it's actually part of the record at this point. You tendered it as MARTA footage, not MARTA still shots and footage.
That's fine. We will leave that one out.
All right. So that still leaves us with what they've written here as geofencing phase 3 results and geofencing map. And so to that, I think they're referring to, what came through the testimony of the map with the dots. And so is that something?
itself with the dots. I believe
The plotting.
the map with the blue circle and the dots, I believe they can have that.
Okay, it's just a notation.
Okay. Again, if the parties come to an agreement, that's fine. Just let me know.
We're agreeable with that, Judge.
So is there something, let's make sure we're on the same page. What exhibit are we talking about?
It's over there.
Given that, Judge, I just had a clarifying question about the drive that you want to put the other MARTA videos on. Would that be entered through a court's exhibit?
That's the problem.
So 507 is what it is. That's one we'll keep outside here.
That
And the one we would send back, as long as both parties look at it and are in agreement as to what's on it, I don't think we need to formally tender what is in essence a duplicate for the record. As long as, again, both parties have looked at it and agreed what's on it. And we go from there. And they're not introducing new evidence. This would be the similar manner of giving them a redacted indictment or giving them multiple copies of the charge rather than just the one that I tendered. So Yeah, I think we'll make sure to do that.
What are they talking about? Age, you think, or?
They're talking about, well, when they talk about the map, I'm assuming this, but the problem with it is it's got writing next to it, and that cannot go back.
I'll just, again, in terms of what they're referring to, all I've got is geofencing phase 3 results and geofencing map. And so I'll leave it to the parties to give me direction. What exhibit are we referring to that you have, Ms. Levinsky?
It is part, no, it is part of the exhibit that was handed in by Jane Bryant, exhibit 498. And we said it doesn't go back because it has all this writing at the sides.
And so is your position now that it should go back, but that part being redacted, or it should just not go back, period?
I would have said the map itself goes back, not that, but with the writing redacted.
Okay. And so for the proposal, I think on the floor is that for exhibit 498, that if the state can present us with a redacted version that removes essentially what would be a duplicate for her testimony and the undue emphasis on what her testimony was, that would then.
There's more to, yes, I apologize.
No, I'm done. I'm still just trying to work through all this. What is it? And maybe the state disagrees entirely and thinks that the text does go back. I don't know. Y'all tell me.
Your Honor, just for clarification, there are 3 sheets on 498. It is a document with 3 sheets in it.
Or 5 sheets or 6 sheets.
Well, that's a different exhibit, and I'm going to get there. I mean, I'm not sure that is, I need to. I don't think summaries are barred by the continuing witness rule. But in abundance of caution, I could redact these.
I mean, look, if your position is that this goes back in its entirety, we can hear argument on that. Perhaps they do. I don't know. I'll consider your arguments, do some research. But we don't have that now. So what we will do in response to their question is I'll bring the jury in, I'll instruct them on the MARTA video, tell them about this laptop, and then let them know we're still discussing what we can and cannot send back, and go from there.
And there is a second exhibit, which I think is included, that was also introduced by analyst Bryant, and that is 514. And that actually is what I think they're referring to with all the dots.
And that was introduced over defense objection as a demonstrative. And it does not go back, Your Honor.
Well, the objection at the time it was introduced?
It had never been produced before.
It was a discovery-related objection.
Yes.
Okay. Understood. I don't see how that would play into the analysis we're doing now, but noted.
It's a demonstrative.
Now that.
Demonstratives don't go back.
All right. So, Mr. Wilson, that would be the question is, it is my understanding that demonstratives should not go back. So is this, and would you properly classify this as a demonstrative?
I would. So I think they could view it while they're in the courtroom.
That's what I flagged. I don't know about that one either. I honestly just don't know the answer to that. I haven't had a witness ask us or a jury ask us about that. So again, I want to let the process keep flowing. I'm going to bring them in here. I'll say we're still discussing other aspects, and we'll tell them about the MARTA video. And then it sounds like the only thing left for discussion is whether you think 498 is a summary versus a demonstrative, and whether you think juries can view demonstratives in the courtroom versus having them in the jury room. All right. Is there anything else before we bring in the jury? Seeing none, Deputy Scott? Liz, why don't you just come sit in the witness stand, I'll hand it to you. And you can then give it to the, or no, wait, I'll give it to Deputy Scott. That's fine.
Rise for the jury. Mr. President, Judge.
Thank you, Deputy Scott. Members of the jury, I received a note, I believe, written and signed by on behalf of you all, and it lists 3 items. And I presumed from reading this note that you are requesting to view these items that were discussed during the presentation of the evidence in this case. And I'll just note at the outset that there's a very complicated set of rules of what exhibits we are allowed to have with you in the jury room and which ones we're not allowed to have with you in the jury room. And there are even certain exhibits that you're only allowed, if you want to see them again, that you have to see them for whatever reason right here in front of all us on the screen, and we watch you view them again. Those are just the rules that we have to deal with. So we're working through the application of those rules. One item, though, we have come to an agreement on is that we are going to send back with you a external hard drive with the MARTA video footage. And in order for you to view that, I've got a laptop provided by the court. It's been wiped of Wi-Fi and any other programs. And so you should only be able to use it to view those videos. However, just in an abundance of caution, if for whatever reason you can do anything on this laptop other than view videos, my instructions are to you that you're not to do those things. So I'll also note that as part of that exhibit of the MARTA footage, there was one video that had some sound on it. I believe this is the video showing actual footage on a train. And if a video has sound, that is not one of those things we're allowed to send back with you. So if you want to see that one, you'd have to request that, and we'd come out and watch it together. So I'll provide Deputy Scott with this laptop and the charging cable. We'll send back that external hard drive here in just a bit. As to the other 2 items you requested, we are still discussing just how and whether we can send those back with you. So with that, you may retire to the jury room and resume your deliberations.
All right.
All right, any objection to the recharge is given on behalf of the state?
No, Your Honor.
Anything from the defense?
No, Your Honor.
All right, and so state is preparing that duplicate hard drive as we speak, as I understand it.
And Your Honor, perhaps do we need to clarify what they're actually looking for when they say phase 3 and
I think I tried to make it clear that I'm presuming, I think they're just going to need to know that they need to write another note to give us more detail. If not, I guess when we come to a decision of what can and cannot go back, I can bring them out and instruct them or write on the note an answer to this question. So point taken. Let's first see what the answer is.
No. I need a 64 GB hard drive, thumb drive.
All right, we're gonna go off the record, and we have some other folks with business they've been waiting patiently for, and I think we need to get to that since the state's not ready at this point. So let me just check in. Maybe we'll start with Mr. Pennington, Mr. King. Y'all feel free to approach it. Let me give you this, Ms. Smith, so I don't lose it.
Welcome back, Mr. Pennington. That's a new case.
Well, there's something I gotta get going on. Actually, I do have a question. For next Friday.
Oh, yeah, maybe. Just that one. Hold on. Calling it in for trial?
It'll be comfortable, so we.
Come back, it seemed like it took that long.
Well, if you get that damn thumb drive.
I also was gonna make sure that was back on the way before I did that. But where's the file?
We're stuck in a real trial.
Okay.
Oh, to the immunity hearing.
Yeah. Thursday.
And that's what we've also made an offer which makes our case. That's, so we have, and you probably.
I know that.
Yeah.
What's on the front? What's it?
Well, probation is recommended 1 year, but worse than. We've discussed this, and I've talked to the probation officer who is ready, his actual probation officer, who I have ready if we want to talk to him.
This stuff is huge.
Yes. Yeah, it is. It's too big.
Okay.
No.
I'm okay.
Oh, I got a spare say.
Is there someone in your case There was one right here.
Which one?
I think there was, I saw a link flash drive in your file box, but it's
right.
horrible definition doing all those files, so it may have come out.
Yeah, I guess.
It's like, it was just like floating to the bottom.
So I changed boxes.
Oh, did you?
It's these. Oops. I don't want to change.
Oh, yeah, it was in the black and silver one.
And
I
these
forgot
are
that one.
correct.
Yeah, I heard that. You're supposed to send us a signed form.
And we don't have, so we need to complete those. Mr. King is asked.
Hang on. How big is this?
All right, so let me, before I toss it.
No, this is only 32.
I remember
Sorry, this is only 32.
Okay.
It was like state's theory of days was the victim was so. It wasn't always the intention replicate the state. Because I've seen a lot of other cases come through. It refuses, makes the cruelty, which is not a registry offense.
Well,
Was that actually the state's intention to
Yes.
make him register?
yes, and I would say that because that was put in the litany that he would have to do the special conditions. And the charge itself is, there's statutory requirement for it to be registered.
For that particular charge.
Right.
What I'm saying is the state does have a track record of changing the charge. Didn't remove that as required. And so, would you still in retrospect think this is a case that's fine and one that you need to register? It's just I'm just putting that out there.
I mean, we could discuss that. I would discuss that more internally.
No, that's not what we're solving today.
Right.
All right, Mr. King.
To add on to that point, and I don't need to.
Check that there's nothing on there that's relevant.
She's
going
very-
to. So revolving door ever since.
So she decided to call for it before he said that he didn't mind. But we were up against.
Were we on a trial calendar
We
or
were on a
something?
trial calendar. We just couldn't do anything else because they wouldn't change the charge. They changed it to second battle. One of the things. Because.
Prior to.
From the get-go, whoever this speech was that, again, I mean,
Yeah, well, we got that nasty rap about that. Got the nasty rap about that. Make sure it's kept off.
Okay.
I was returning calls.
Your mailbox is full.
Our concern with the first offender is that you basically avoided probation for.
So it's probably.
So,
It was actually reported. I know, we went back and forth. But when he.
That was.
Now he sounds like a liar.
no, my concern
Well,
about.
no, I went to the office.
And that was relaxed.
What I'm saying is that.
Nice relaxing
I
day.
feel like you
deserve a yelling action.
Lord. I'm gonna get you guys. I'm no better.
So first
I can't
offender
this
is
man,
not
I'm no
down to
better.
5 to 6 years or something.
I think if it did 3, I was just gonna add another year.
We could.
This mail is email.
That would be, yeah,
You see what I mean?
we could make it.
No, it's fine. You email me, that's what, people leave me voicemail.
Maybe the bid date, I think it's the maximum of 3 years.
Right, so-
Statute, so, but I can also, I mean, the bid date means there's no revocation.
Right.
Reputation.
So if we have a ramification, we.
This is not the way.
Yeah.
It does.
He's getting questions what the format takes.
So they gave me another one, and that being functions now, so I've got.
Of course.
And
And I have whole barely functioning one, and barely functional.
Perfect.
And
Yeah.
that way, when I try and play every message, it won't play audio. Get to it for shit.
That seems like it sort of defeats the purpose of
And
having
what
messages.
let me read.
Oh, the transcription?
Yeah.
Yeah, but that's not always perfect though.
No, it's not.
Yeah.
Wait, hold on. Right, I mean, he's willing to live with that. He actually did some form as a senator.
I need to. It was, this one,
And then,
Oh,
this one. But
but anyway, before you make a recommendation, that might affect how long, then you know. 'cause-
but this one, now, this one has got 5 minutes worth of power. So I can't even get it to the agenda. I'm not sure the other one is there. Oi, oi.
Correct. That folder.
Yes, I'm not.
Everything else is fine.
Yes,
That
is it
folder.
copy?
Yes.
Perfect,
Well, I mean, I've only got, I'm only through one.
perfect.
Well, I don't know about that. Depends how much space the other files take.
Are you about as technologically aware as I am?
No, well, I don't know how aware you are, but I'm okay, but
Until
Yeah, that's sort of,
If he's already done 2 months, it'll be in 30 days for me to get everything.
that's kind of my calculation of the week.
Confirm, I don't want you to give them bad information. I'm just, let me finish that though. Is that, I mean, I think the state, I mean, reality is that probation has been fired up on this for a while, and I think it's not unjustified. And so, I agree with you all that in this situation, when there's not a new offense, keep the first offender, it's fine by me. And I'll let y'all continue negotiations of whether it's really in the best interest of everybody and all involved, whether he stays on the registry. But in terms of the sentence, I guess the 6 months is reasonable based on what happened here. But we can't be going to 6 recommendation. And then that's gonna be coming with the caveat that we start making sure that seeking again. That he's got, do they want a signal?
right.
Well, maybe not, but I'll look, I'll know.
Oh, you need the time.
Jinx, but.
Yeah.
Free from here.
But that's, I'm good enough for it. Yeah.
Okay, I'm gonna talk to them to understand, so I can advise them properly.
Agreed, good. I've got split.
Is there?
One some, one some.
Yeah, she.
You know.
Permission.
Thank
It's
you.
been at 43 days.
Yeah.
I need to stay for.
We're on forums and that sort of thing, I guess. He's asking if he's step. Do they need anything?
Look at it.
No, I haven't given it to him. Mr. Wilson, where are we at on this?
It's in the middle of copying, Your Honor. It's taking a while.
Let him know it's still trick.
Yeah.
Now.
Debbie Scott, you can let him know lunch is available too.
I'll be, you text me and I'll pick the background service.
That's good.
It's the same.
Not really like using a sports person, just go to the games.
Probably not.
And David, I went to Oklahoma State for.
All right.
Be sure to mix with those cameras.
Well,
Let me see if it'll go on my hard drive quick and then, well, I don't know that that's gonna help. If it's copied.
Well,
From my hard drive, would it speed it up? It's like 20 minutes.
let's go, come back.
Yeah, sure.
We don't leave this.
Cheryl.
I'll take up for him. Gotcha.
No, I don't, well, I mean, you might get a wrinkle. We can't have that.
It's almost there.
We can't have that.
I could try to put it on this computer.
Not yet.
I don't look for this. What can I?
Lewis.
I got nothing to lose but time.
Why were you in that?
I don't, somehow. Yeah, so no trigger one.
Nope.
Is cooperation or a colloquy as part of this? There's no condition that he has to testify truthfully next week?
No, our intention is that the co-defendant would be a potential reduction or potentially a null pros.
Which is the DNA?
This
Yeah.
is the defendant.
Okay. But the other defendant is cell phone records,
Yes.
and the registered car is the other defendant,
Yes, I could speak to Deputy Miller more about that.
the one on the video as well.
Yes.
Okay. I guess we'll take that up Monday.
Okay.
Okay. Hold on one moment. I gotta get you to sign.
Yes.
Can I sneak in the box?
Go ahead.
Okay. Talked to probation about 2 people, and they said they're not. So I was gonna ask for the 90 days, but because of that.
Is it ever? I mean, I know it comes up somehow. I just maybe Mr. Simon can weigh in.
It's solely in the discretion of the sheriff whether to forms of order for any sentence that's under 1 year. Solely in discretion.
How do they use that discretion? Do you know?
It depends case by case. Some cases, even under a 12-month sentence get sent to DOC. Some cases get 2 for 1. If they're a trustee, they technically get 3 for 1.
But it was a 6-month revocation where he served 43 days.
Like I said, it varies. I just had one on a 9-month revocation get sent to Jackson or something where he would serve like 4 months. So I don't know. But generally they get 2 for 1 unless there's behavioral issues in jail or anything like that. But there's no guarantee and it's solely discretion of the sheriff.
Thank you.
All right. Y'all confer. Let me know if you have a joint recommendation. All right. So we've got Mr. Lewis here. Everyone's ready?
Yes, Your Honor.
Yes.
Ms. Rutland? Okay. Then we'll go on the record. This is 24 SC 005 180 State versus Robbie Lewis, who's here present in court with his counsel of record. Mr. Mitchell, we are scheduled to begin trial on Monday. However, I've been told the parties have reached a negotiated resolution. And so with that, Ms. Rutland, if you, Mr. Lewis will proceed.
Mr. Lewis, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name.
Robbie Lewis.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today?
No.
How old are you and how far have you gone in school?
46, 12th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you are charged with the following offenses? Armed robbery, kidnapping, false imprisonment, 2 counts of aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon?
Yes.
And do you understand, have you reviewed the charges with your attorney and have they advised you about the potential minimum and maximum sentence for each charge you're pleading to?
Yes.
Okay, and for armed robbery, that is 10 to life imprisonment. For kidnapping, it is 10 to 20. False imprisonment, 1 to 10 years. For aggravated assault, 1 to 20 years. For possession of a firearm during the commission of a felony, 5 years consecutive, and 1 to 10 on the possession of a firearm by a convicted felon. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer, Mr. Mitchell, about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Do you need any more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment?
So waived for the purpose of this plea.
Do you waive any and all defects in the indictment, including with respect to name?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of, for count 1, armed robbery, an amendment, to robbery by intimidation, just with a sentence of 20 years to serve 10 with the balance probated. on kidnapping, 20 years to serve 10 years with the balance probated. False imprisonment, 10 years to serve. Aggravated assault, 20 years and 20 years with 10 years to serve with the balance probated. Possession of a firearm during the commission of a felony, 5 years to serve consecutive suspended. Possession of a firearm by a convicted felon, 10 years to serve.
All right, I think we need to pause here. I didn't understand. I want to make sure I understand the recommendation here. I know the state had filed a recidivist notice in this case. And I presume, is the state now withdrawing that as well?
Yes, Your Honor.
And so this is a plea to robbery, meaning he'd be parole eligible,
And kidnapping.
and kidnapping, which is also parole eligible. If the state could just walk me through the basis for the reduction. I mean, I'm familiar with the facts of this case, and I'm familiar with Mr. Lewis's history. I think this is the most serious case I've seen trial division have, maybe in the past year. And as I understand it, he was serving a sentence, I think a 15 or 20 year sentence back in 2010 in the district attorney's office through, I think, the conviction integrity unit, decided we're going to amend that sentence and let him go a little early. A year and a half later, we have this. Victim's pistol whipped, put in the trunk of a car, and you've got DNA, cell phone records, and video footage. Just lay out the reasons for this reduction. Ms. Rutland, I'll let you, Mr. Mitchell, I'll let you weigh in.
Okay.
I would ask if I could, Deputy Miller on this, because he did handle the negotiations from prior to when I got the case, if that makes sense. So I'm not as privy to the negotiations as he would be.
And I understand you're a conduit. And at this point, if the offer's been conveyed and we're on the eve of trial, then at this point, probably Mr. Mitchell's relied on it, and we have to hold the state to that offer because the defendant would be prejudiced otherwise. But I just want to make sure the record is absolutely clear what this reduction is based on. Mr. Mitchell, maybe you want to weigh in? And is there something I'm missing? Maybe there's, sometimes the evidence isn't as strong as I'm led to believe.
Yeah, so this reduction is really based on, it was provided to me with the armed robbery. And again, Mr. Lewis having some medical ailments that we've discussed. And also we are aware of his record, but this was an offer that was in the record as far as the time, the sentence exactly was at 10 years. And so this was, I asked Deputy Miller if we could keep the numbers the same, would he be able to do robbery by intimidation? I have seen more severe armed robberies and aggravated in Fulton County. And so.
And I'm not going to fight you there. I mean, the injuries here, thankfully.
Yeah.
It's not really so much we're talking about, but you take the history.
Sure.
It's just not a really great presentation here.
Yeah.
And I didn't think there was anything problematic with the case, evidentiary wise.
Right.
So.
Well, like I said, Your Honor, we wanted to make sure to resolve this case. And, Mr. Lewis is getting to a point where he does understand this would be a blessing, a gift, if you will, to get through this. But I've explained to him all the facts, and I've talked to the state about, pled his case to them about, the things that he's been facing, experiencing at his age and some of the medical ailments that we've talked about. And so, we do have a probation period, and I know that Your Honor would be really willing and looking to revoke probation if that's something that actually has to happen with Mr. Lewis, but it still is a 20-year total sentence. And so we would just ask that Your Honor accept this negotiation at this point. But we definitely, we're humbly coming before you. The severity and the impact and your concerns, Your Honor.
All right. Well, Mr. Mitchell, you've done a remarkable job in a short amount of time on this case with your negotiations. And I think I've noted my concerns. And for the record, I think it's clear where this reduction is coming from. And I'll just add that I find that there's a factual, and we'll get to this, I'm sure, during the proffer, but my role is to make sure there's a factual basis. There is one. He's being held accountable in some regard, and I think you're saying he recognizes this is just an incredible opportunity the state is providing him once more.
And he know this is, we getting at a point where we know the buck stops here. I mean, it's time to mature, if you will. So.
All right. Well, I would just further note that for the reasons I've kind of laid out, that at this point on the eve of trial, I don't think it would be in the interests of the case or Mr. Lewis's interest, certainly, and to reject this offer. But I'll note that if the district attorney is concerned, that the bench here in Fulton County is soft on crime. This offer did not come from the bench. Mr. Rutland, you can proceed with the colloquy.
Mr. Lewis, do you understand that the court does not have to accept this recommendation and can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would, and that this is true regardless of any advice by your attorney or anyone else?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, you will be guilty of a felony which carries a sentence of 1 to 10 years in prison?
Yes, ma'am.
I'm going to read a list of rights that you are pleading, but that by pleading guilty to, you are giving up. After each right, please indicate that you understand. Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury.
Yes, ma'am.
The right to remain silent and not incriminate yourself.
Yes, ma'am.
The right to confront witnesses against you.
Yes.
The right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at the trial of your case.
Yes, ma'am.
The right to the presumption of innocence.
Yes.
The right to testify on your own behalf and to present other evidence.
Yes.
The right to subpoena witnesses and compel the production of evidence.
Yes.
The right to have the charges against you proved beyond a reasonable doubt.
Mm.
The right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a plea of guilty because you are in fact guilty?
Yes.
How do you plead to the charges of robbery by intimidation, kidnapping, false imprisonment, aggravated assault, possession of a firearm during the commission of a felony, and possession of a firearm by a convicted felon in indictment number 24 SC 005180?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging this guilty plea?
Yes, ma'am.
Thank you, Your Honor. And I believe we have stipulated to the facts unless you would like a short summary.
Do you agree there's a sufficient factual basis, Mr. Mitchell?
Yes, we do, Your Honor. We stipulate.
All right. Anything pending on the behalf of probation for
No, Your Honor.
Thank you, ma'am. And actually, you know what? Did we get for the record your name? I don't think you've been with us recently.
Teresa Cardi.
Thank you, ma'am. All right, Mr. Mitchell.
Yes, Your Honor. Again, my client is 46 years of age. He is a native of Mississippi. He does acknowledge he has an extensive history. I've talked to him. He would attest that we've talked extensively over the past 2 weeks about this scenario, about the situation, even about the state's position, even the court's potential position. And so we just ask that, we humbly ask that you accept this negotiated agreement. My client did want to ask if we have a recommendation put in that he be able to get treatment and serve at a county camp. That's our request. I know that may be up to the discretion of the corrections office, but he wanted me to recommend that he have service at a county camp so he could be able to get some services that he desperately needs.
And so what language are you proposing, Mr. Mitchell?
I don't know.
All right. Then I think the Department of Corrections is familiar with Mr. Lewis. I think since he had been in their care for about 10 of the last 12 years or so. Maybe it was 10 out of the last 15. I don't remember exactly, but I think they'll be familiar with him and know his needs and how best to work through that.
Okay. Yeah, he was saying there'd be a work campus that he was requesting.
All right.
Yeah.
We'll note that for the record here. And so, Mr. Lewis, just to confirm, you understand the nature of these charges, including the ones that have been reduced?
Yes, sir. Yes, sir.
All right. And you still wish to waive your rights and proceed with this change of plea?
Yes, sir.
You're doing that because you committed these offenses?
Yes, sir.
And Mr. Mitchell, you satisfied your client is confident that this plea is knowing and voluntary and that there is a sufficient factual basis?
I do.
All right. I agree. I find that there is a factual basis and that this plea of guilty is entered knowingly, voluntarily, and intelligently. And I'll accept the plea. Mr. Lewis, I'll sentence you as recommended by the state on counts 1 and 2 as reduced to robbery. The sentence would be 20 years to serve, 10 years with the balance on probation. I didn't catch actually the tail end of that recommendation, but for the possession during a commission, what was the recommendation on count 6?
5 years to serve consecutive suspended.
All right. And were there any special conditions?
Yes. Stay away from the incident location, no contact with the victim, no drugs or alcohol, no weapons, and no contact with the co-defendant.
All right. We'll impose those conditions, and those will also be the conditions of the suspended portion of your sentence. I'll also note that for any technical violations while you're out on probation, those will be handled directly by the sentencing option system with a sanctions cap of PDC or RSAT.
Judge, I apologize. The victim is on the call. I forgot to mention that the victim is on Zoom with us and would like to make a statement.
Certainly. And so can you address this person? Just let us know. I don't know if you could remind me of the name.
Mashiri.
All right. So do we have a Mr. Mashiri joining us on Zoom?
Will you please turn your camera on, Mr. Mashiri? Oh, he might have,
Nope. I think we got somebody.
okay.
All right, sir. We can see if, can you go off mute as well so we can hear you?
Sorry.
No, nothing to apologize for. We can hear you loud and clear. And sir, as the one of the victims in this case, you have the absolute right to be heard and to say what you think about this case and what you think the sentence should be. And
I'm
we'll
gonna
have that
accept
reflected in the
them.
record.
I don't accept the 10 years, sir, 20 years or 10 years, for him. He robbed me, they beat me up, they hit me with the gun, they stole my money, they took all the key to my cars and stopped my business, for almost, 3 months. And I'm suffering from that. I'm not accepting it, Your Honor. They hurt me so bad. They still, I'm hurting from that. And I have to have surgery on my eyes, 2 people, they robbed me at 8:45. They kidnapped me. And the friend of mine, came. They put him, inside the trunk. Twice, and after that they moved him, they put me in another, trunk of the car, and they took me hostage for 45 minutes around Roswell area, and they want to know $250,000 cash from me, and they asked me for my Rolex watch, and I told them I don't have Rolex watch, and they hit me, with the gun. For watch, to beat me up is worth it? No, this person must be stay in jail forever. I don't accept that.
All right, sir. Well, you'll get no argument from me. Certainly the state had the ability, if they wanted to seek a life without parole sentence, but they decided not to. And I suppose you're just going to have to inquire with the district attorney why that was so. And we're here today on the verge of trial on Monday, and the state's just decided they don't want to try this case. And so my sympathy goes out to you, sir.
I know, but the state, they didn't get hurt, sir. I'm hurting. Every night, every day I come to my business, and I can see that, they beat me up. That is not, right, to make decision, for me, the state, sir.
And it was the state in communication with you to convey this offer?
No, sir, they didn't, sir.
Really?
No, they didn't.
This is the first time you're hearing about this?
Yes, sir.
Ms. Rutland?
I believe that someone spoke to him maybe Wednesday.
Yesterday, someone, they called me and they said, they have a Zoom meeting, tomorrow you have to come to court. Nobody told me nothing about the case, I could discuss it with my attorney. Nothing, sir.
It's my understanding that an offer was conveyed before Deputy Miller got on to the case. And so
Nobody told me nothing, Your Honor.
That's where it looks like it fell apart.
Nobody told me nothing.
Until yesterday.
Until yesterday, yes, sir.
Ms. Rutland, anything you want to add here?
I know that the victim witness advocate who contacted you yesterday was just transferred to Judge McAfee's courtroom in the last week. And so this information has been new to her and myself as well, and Deputy Miller. So there should have been contact made to you when the first offer was made, and that, because it wasn't, that was a mistake. But, we've reached out, and I believe our victim witness advocate, Ms. Williams, is on the call and would be happy to speak with you further after this hearing.
Sure. But, I came, several times, to the court in the morning at room 5A, and they postponed it, I came, 3 times to the court, the different times. Nobody, told me about, what they're offering the state, for him. And where is my key to my cars? Still, I have it. I spent over $20,000 to make the key to my cars. And these people, they got the key to my car. What they did to it, Can you ask them to recover some of them? Still, I need, rest of my car's keys. I cannot afford, as a citizen, what they did, to let them, go free, And nobody discussed this one, with me. I'm in pain, I'm hurt. I don't know what you guys, make the decision. You have an attorney, friends, and you settle, with each other, without, getting permission, from the victim. That is not right. But, the judge, he makes the decision, and I'll go accept, judge, decision, but you guys, you cannot, make decision, for other, people. You have to discuss it and make that, person, happy and satisfied.
Well, I agree with you, sir. This is something that you should have been kept in the loop on, and that's actually the law in our state. And so,
They didn't, Your Honor.
Understood, sir.
Your Honor, this has been published, that offer has been read on the record and published. And if the victim has been in court, the 10-year sentence has been published since January 2025.
10 years to armed robbery. 10 years to armed robbery.
But the time, though.
The time's different when it comes to the parole calculations. This is a different offer.
Understood.
All right. Well, sir, as I said before, I want to thank you for being here to express your opinions. They are part of the record in this case, which is a public record. And I want to say on my behalf that I'm sorry you had to go through this. And I know this probably isn't the best reflection of our justice system from your perspective. And so, again, I want to thank you for joining us here today, sir. There will be a co-defendant on Monday that'll be brought here to court. And if you would like to join us for that hearing as well, I want to make sure you have that right.
Sure.
Okay, we'll
But
keep
the
you
same
notified.
thing, why different? You guys, already make the decision, why should I, be there? They make the decision, for me. What happened if I was, doing those things, to them? What happened?
Right. Well, I don't know what the outcome will be on
different.
Monday. All right. I don't know what's going to happen on Monday. And I think you being there and weighing in and being heard again is something that you have every right to do. And I think you should do.
Only I received, the letters, they emailed me yesterday and they said, I have to be there, Tuesday morning at 9:00, to Fulton County. And me and the two other, people, we have to be at the court. Still, we have to be there Tuesday morning at 9:00.
You do not. You do not have to be. Okay.
But the subpoenas,
Now, I don't know about the subpoenas. They should also be talking. They shouldn't just be slapping subpoenas in your hands and not explaining them to you. Is that what happened here too?
Yes, sir. What they
Okay.
said.
Well, they're going to have to be in communication with you. As of now, we may still have a trial on the co-defendant next week. And
Thank
so I
you.
think that's what that's about. And
Yes,
so
sir.
Monday morning, we'll know whether that's going to be a trial or not.
Thank you so much, Your Honor.
All right. Take care, sir.
Thank you. Bye-bye.
All right. As I mentioned before, I believe we've outlined all the special conditions and the other terms of the sentence. Is there anything else that needs to be reflected on this record today on behalf of the state?
No.
Anything on behalf of you, Mr. Mitchell?
No, Your Honor.
All right. This case will be closed on for Mr. Lewis. And Mr. Mitchell, you don't need to report on Monday.
Okay.
All right. We're off the record. Oh, is there anything we need to advise on the record from probation?
Yes, where will the defendant be residing when he gets out?
Know where you'll be residing?
You may not know that. That's several years from
But
now.
is it Georgia? Because I heard. you
Yeah,
said
in Georgia.
Mississippi.
No, I live in Georgia.
Okay, so then get to report to 276, 48 hours after release. And I'll explain the rest in the back.
No, I meant no.
Thank you, ma'am. All right. We're off the record.
All right.
Do you need me? Okay.
Yeah,
All right. Do we have an agreement on this exhibit, the MARTA footage?
It just finished. It took
Long time.
a long time to copy, but I think I'm done with it. I wanted them to view the two copies to make sure everything
Certainly want to do that.
is the way it should be.
This isn't on the record.
Over and view it.
I don't even know if we need, well, we'll see where we go.
As you can see, the Lexar is the original exhibit. And the US is the that's So. Yeah, I just want to make sure that it's totally, and I would attempt to place them. At least one.
Well, why don't we play it on the laptop it's actually gonna play on? When we do
Well,
that.
I mean, if there's a problem, I want to be able to take care of it on this laptop rather than using that laptop. to try
No,
to
yeah,
copy things.
that's fine, taking care of the problem.
That's fine.
I'm not saying it's copy it to the laptop, I'm saying just make sure that this plays on that laptop.
Oh, no, I understand that.
Yeah.
I understand it. Yeah, no, that's fine. That. That's not mine.
Oh.
Let me. There's something in here. Okay, wait. Yeah, just close it. Okay.
Oh, white noise.
That's the white noise. I'm gonna close them out.
I will stop it.
Oh, yes. You know if there's any problems. Yeah.
Back to Mr. Pennington. Do we give this back to Mr. Pennington or what?
Why are they holding it?
Because they won't sign it or accept it until the revocation. I'm gonna step off so you can grab the note.
Good to have the special conditions on the docket anyway, correct?
I'm sorry, I didn't catch that.
He didn't have special conditions signed from the plate, correct?
I don't know what the final disposition
Yeah,
says.
so you can go ahead and file them, because he needs to have them on record anyway.
Do y'all need to sign it, though? There's a spot for community
Oh, yeah.
officer. I'll go in the office.
Oh, so he gets it and goes to the judge. Okay. It's just, there's so many things about evidence like this that I don't understand, like, you know, why can't a block of paperwork go back there? Why can't this map go back there? How do we do this better, you know? So a good example from what I've been talking about all morning. You do a picture of the house. You don't write on there 1095 Old Woodbine Road where Kay Thompson was murdered by the suspect. You just do a picture by itself. You don't do a picture of a gun and write murder weapon. Okay. So that may be why Robert couldn't use my slides, because I had arrows and
Some of that would have been projection.
okay. Holy mackerel.
Yeah, looking, you know, you can do
I
that,
think that we've got
but
that
it
one.
altering.
Pardon me?
I think that we've got that one.
Photograph, you might have a girl, it's kind of like this, yeah, he's still talking.
Right.
I just saw the email of that boy. Yeah, I saw the. Trial? Well, so do you think they are still in trial? Well, also, let's just get his client here because we're ready to fire him. Yeah. Mm-hmm. Ready? All right, we're back on the record. I've now received another note from the jury minutes ago. I've labeled it Court's Exhibit 4, and it reads, security camera footage of rear of the house. Again, they are frugal with their words here, but I interpret that as being a request to review
506.
506, which I think they already have.
It may be on Ms. Smith's desk, Judge.
Thought we had talked about them already having that, but why don't we come take a look? And this is also a USB.
And I've already reviewed that.
Yeah, okay.
Are there any of the other concerns we had about everything else about 506, or is 506?
506 has been checked.
Do we know whether that actually plays on the laptop in there? Great. All right. Well, then without objection, I would say we send back 506. I'll direct Deputy Scott to do so. Is there anything else we need to take up right now on the part of the state?
None from the state judge.
Anything from the defense? We'll be in recess till we receive further word. If anyone needs to inspect the note, here it is along with the other one. We'll be off the record.
Thank you.
remember the evidence, and your notes and discussions with your deliberation.
So in response to the rest of their note, at this time, it's the position of the state that nothing further should be provided to them?
Well, I wouldn't want to, I would.
Not in response to that specific note. Maybe we get another note that says
Well,
more, but.
I mean, I guess specifically, I thought it would be a court response, that if it's I guess if the proper response is that you are to rely on your notes or allow your recollection of the evidence, that would be this response as opposed to one party is responding to that note. I guess that's the way I took the state is.
Well, I mean, certainly I'm happy to write a response on it. I thought it was unclear from where we left off the conversation before I had to go do some other stuff. If the parties were actually saying, well, actually, maybe some part of these maps come in if we scrub the language, or maybe they all come in because it's under some other theory. I think we had left that in very much a state of flux, and that's what I'm trying to.
So I want to make sure I'm not confusing. So there was discussion about the maps, and there were discussion about separate Google records. I guess it was the searches or whatnot. So as it relate to any Google. The third phase, I think.
Just whatever they wrote on Courts Exhibit 3, I think it was.
Right, so I think if the third phase
Not the
is
one.
in reference to the print out Google searches, then I would say that they are to rely on their recollection of the evidence because that wasn't tendered in as a separate exhibit, printout itself.
The geofencing Phase 3 results?
Yeah, if this is what they're talking about, which is, I'm just guessing, then that wasn't.
That wasn't tendered, okay.
So then that would be the response to that. But then as it relates to the demonstrative,
Just as a geofencing map, that's what they put in there.
my understanding was as long as it wasn't anything narrative on the exhibit, then they would be entitled to come out in the presence of the court and review it because that testimony, the purpose of that testimony obviously was to aid with the testimony of the witness at the time of the testimony. But and I don't want to. My main purpose is to not run afoul of the law and what's permissible. But my understanding is that they would be allowed to come out and view that in the presence of the court.
And what's the specific exhibit that you think would cover or satisfy their request for a geofencing map?
So there were, I think that one exhibit, I think it contained 4 maps, I believe.
I think what the geofencing map is the one map with the big blue circle in the center, but it has writing on the side. And that is my objection to it going back.
Do y'all have an exhibit number for me?
It is portion of exhibit 498.
Okay, 498 is what we're talking
Part and
about.
parcel of exhibit 498.
And Mr. Fawcett, if you're saying that you think the jury can come out and look at it, are you also saying what's your position on the writing on it?
Well, and I don't know if the elimination of the writing, I don't know if that eliminates the issue of this going back with the jury, but if that's the case, then it may be just a matter of recopying this in color.
Especially if it was entered as demonstrative, I think then there's another continuing on this issue. And then Mr. Fawcett will be right, it'd be safe to bring out.
Just bring it out,
Instead of
take out the writing and just let them look at the map if they want to. But I would wait until they ask for anything else. At the moment, they seem to be working.
I certainly don't disagree with you there. The issue is where I left it with them is we're still talking about it. And so I could see them saying, well, they've been talking about it for hours and maybe they'll get us a decision at some point. So I'm hoping they're not waiting on us as well. And who knows? We really don't have one way to know one way or another.
I would think if they were waiting on us, they would let us know.
Yeah.
I think that to sort of send them a note saying, well, you can't have more now, you've got to rely on your collective. They put them in a situation where they will not want to ask for anything else. And we don't want to do that.
Mm-hmm.
So perhaps we should just wait
Okay.
until we hear from them.
Well, maybe we should do this to make the best use of our time is maybe you go ahead and prepare one without the writing. And then if we get a note where they're like, hey, we really do want these maps, now we've got it ready.
Or, another alternative could be to send a note saying, you have the ability to come out and use the demonstrative aid in the presence of the court anytime you desire, or you may continue to deliberate. I guess let us know.
Okay. And I'd consider that. I wouldn't want to send that to them until we have that demonstrative ready. Because if they say, I'll take you up on that, and then, well, maybe not. So anyhow.
I think we should let them work while they're working.
I agree. Okay, well, just wanted to clarify that. And so,
When they run out of stuff to work on, then
I thought you were gonna say what I thought worked on the phone.
no.
So, arrows on there.
Right.
So I have to have that without it. Go and get this.
Oh, what about the other pen?
Yeah.
Maybe computer.
the Google fencing map is the one that the other one is not.
I'll give this back to you.
The Google fencing map is the one with the dots. The one with the yellow lines is not a Google fencing. It is her interpretation of where the person was seen.
Okay, I can see that. That's fine. I get what you're saying.
Oh, you have good stuff. It's on my PowerPoint. Do you have it
it's
on
on your
there?
PowerPoint? No, no, go ahead. It's not, just plug it in. She's saying. She's saying that the go. I see what she's saying. It's not off. It makes sense what she's saying. She's saying this is where.
All right, so don't pull it up then.
Yeah, pull it up. So, but it's just not gonna.
Communication.
We can take that out.
Yeah.
I made
Then
soccer ball.
is that allowed to be in there or not?
All sorts.
Is that allowed to be in there?
Probably would.
My kids' birthday cakes, except for.
I did Powerpuff Girls.
Well, this one, that's allowed to be there, right?
Powerpuff.
Probably so,
That's
but I mean, it's still,
I cannot, she's gonna object to that.
if they objected to it, it's probably be area.
Karen and I are pretty close to the same age. We probably watched most of the same
So
show.
what are you gonna do? Do you have a copy of that upstairs?
A couple years
Now,
ago.
Yeah, I can take this and see, just make a color copy of that.
can you make it bigger?
Oh, there's the light. See, the moment I say while they're still working,
Lights on.
deputy.
Yeah, like.
Moment I say while they're still working.
I
I
know.
should shut up.
It's my,
Shouldn't I?
that's my fault.
No, it's my fault. I should shut
Okay.
up.
Well, that's. Something about this. So, well, he doesn't know the next 2 days, all flights are canceled. So he said, like, one of the guys was leaving out tomorrow, their flights are canceled. So he doesn't know yet, may not be going. I saw that we could get yesterday. Secure something, yes, I think so. From all the, community, yeah. I'm not sure about it. Watching the rockets. Yeah, where they, it's like. And that's what we're looking at. Yeah. No, they need to change this.
Man, see, come to order.
All right, we are back on the record. All the parties are present. Since we were last on the record, I believe we handled the issue of the MARTA footage, states 507, where the defense was able to look at a duplicate copy made by the state, and upon agreement of the parties, that duplicate copy was sent back to the jury along with the court's laptop after it had instructed them on how to use that. I've now received another note, which I've marked as Court's Exhibit 5, and it's another list of things. So we have written at the top, James Jones Google search history, geofencing, comma, Google Phase 3 data spreadsheet, and then Christina Servidio's DNA reports, parentheses 6. So I'll tender that for the record if anyone wants to inspect it. And so essentially, I believe they're asking for more exhibits that they do not currently have. I know we've discussed some of these preliminarily, and we can take these up one at a time. So first thing, it says James Jones Google search history. As I understand it from when this issue last came up, that was considered to be a part of the Google records, which I believe were tendered as $4.99, which was a stack of that thick stack of papers, which I believe is on Ms. Lebinsky's desk.
wasn't intended to use it, but.
I didn't, Mr. Fawcett
Yes.
said that when we were, before we were on the record, we were trying to talk about what we were still doing in response, if we were going to be doing anything in response to their last note, which we hadn't fully answered. We didn't come to any decisions or any formal argument, but Mr. Fawcett had said that he didn't think the Google records were admitted. That would be a surprise to me. Any position there, Mr. Fawcett?
Yes, so 499 is the certificate of authentication.
Okay.
Authenticating the Google records. 499A is the thumb drive. Well, I'm sorry, hold on. 499A is the Google certificate. That's the Google documents that were submitted, the certificate. 499 is a thumb drive that contains all the Google records themselves.
And so what did we do with 499?
499 should be, it should be a thumb drive that they have.
Was that in the stack that went back? Okay.
Definitely.
Sorry. All right, so we've located 499, which was not sent back. The state, I think, believes that would be responsive to this request. And I believe they have the capabilities now to open this thumb drive and look at its contents. These were documents that were tendered, admitted as a business record. And so is there any reason I shouldn't send back 499?
No reason from the state, Judge. It's the affidavit and several Excel spreadsheets that would contain the location data and other the different phases that were received from Google.
Let's just make sure there's not anything extra on the thumb drive. I know we had talked about with the business record, it had a search warrant attached to it. We wanted to make sure that didn't come out or wasn't a part of it.
And the affidavit is from Google?
Yes. Yes, so that affidavit, they would have that on there. They would have all that on there. This is all the Google records.
Yeah, 5-ish. Yeah.
Went on. Oh, pick that up.
What's that?
That came, oh, sorry. That didn't, that wasn't in there.
This is the.
Oh, this is.
This is the file that's in there. Yeah, so that's that. Okay. What's that? All right. That's- oh.
the affidavit for the search and seizure for the Google records needs to go.
All right, so essentially for those two files. This is the second copy of that other version. Yeah, just open that key up. I think it's the same. Yeah. Makes sense. So there was something else, but that's why I printed it out.
That's fine.
All right, so I think. This is the last phone. And that's the subscriber information, some of the search one.
But take that. You see, this is all confused. This is.
They don't hear.
This is all relating to the fencing warrant. It doesn't belong in here. This does not belong in here.
They would be out.
Yes.
Okay. All right, so.
Those things are embedded in those things. I think, can we, the printouts that we gave you are from there.
Give them the print.
I don't know what else to do, because they have to sift through all this stuff and you can't make sense of it.
I'm sorry. You had a split.
Let me just check in here. I know council are conferring amongst themselves. So is there an issue with the thumb drive 499? And what is that issue?
Oh no, it's containing other stuff that should not be on there.
And so when they printed out the Google records and it's that big stack that's still on your desk, is that the only relevant portion?
Actually, I had taken the relevant portion out and taken it with me and left the rest here. But in any event, you can't hand them that stack because that was never introduced as an exhibit. The thumb drive.
If the thumb drive just contains that, but in electronic form, then I'm not going to make.
You can't,
Why?
you can't hand them a stack of paper. You can't.
Well, I'll just have to disagree with you there. That if something is admitted in electronic form, we can print it and give it to them if we'd like to. I don't think the medium makes any difference whatsoever. So
I don't believe that's correct, Your Honor.
feel free to find some case law on that.
I believe, Your Honor, that what was introduced, and what was introduced was that thumb drive. And that is what was introduced into evidence. And I said repeatedly, I'd never seen those searches before because I don't believe they're in those records.
You looked at these yesterday and I believe you found them.
I found them in here, but I don't believe that's part of that.
I mean, you're saying, wasn't it on the third page of a PDF or something like that?
Well, so we got these emailed to us from analyst Bryant, The files in here have contained links that I'm not able to open up. So I didn't know how to open them up. So I had Detective Bryant sent those over. So I can't, those files from this thumb drive, I wasn't able to.
Is the thumb drive just meaningless at this point? There's nothing on it?
Well, there are several Excel spreadsheets of location data, and there's a printout with all the computer background program information that contained links in there. But I don't have the programs that I need to open them up because they aren't opening them up for me, and they weren't opening yesterday.
And so, if this case were to go on appeal, how would you expect the Supreme Court to review any of your exhibits? If it relies on links?
I'd have to resolve that.
Yeah, that'd be an issue. So,
Your Honor, I say we remove the two files which are irrelevant, the search warrants and stuff, and hand them what was introduced by the state.
well, apparently what was introduced by the state is illegible because it doesn't have links.
That's fine. That's what we had.
And at this point, it sounds like 499 is not represented by what's in this printed stack that was handed to us and never admitted.
Well, I mean, we can go through the issue of whether something was supposed to be on a CD that turned out not to be. And I mean, I haven't been presented with that before, but I mean, I don't. What are we doing here?
The jury, so as there was my recollection of there being testimony as to the contents of the search and what was searched in the address, but the records themselves weren't tendered in. They weren't tendered in as an exhibit that was introduced during the trial and wasn't tendered in as an exhibit that was sent back with them. They've asked a question about the contents of what was mentioned as the third part of the phase 3. And the question seems to be related to that statement as well as the reference to those searches of James Jones. To that, it seems like the answer would be, since that physical depiction of that wasn't tendered in evidence, that the answer would be that they are to rely on the recollection of the evidence.
All right, so we don't have anything to provide them when it comes to James Jones' Google search history. We have talked tentatively about geofencing Google Phase 3 data spreadsheet, and had the parties come to any agreement on how to respond to that. I believe we had said that's going to be Exhibit 498. 498 is geofencing Google Phase 3 data. And so I'll start with the state.
It's defendants 31. Oh, no, sorry. No, it's not. No, that's phase 2 data. Phase 3 data, I think.
I think there was some mention that was Exhibit 498.
I believe that's this stuff.
No, that's 499.
That's 499.
Stuff or it's pieces.
It's too much.
Yeah, that's 498 is this.
All right. And so
498 is this.
and this do we
This is the thing we said contains writing.
right. And we think that is what is responsive to the geofencing, Google Phase 3 data request from the jury.
No, it's not.
It's not. What is?
It's not, because
Yeah.
this is not phase 3.
Okay.
This is actually phase 1. So it's not this. Phase 3 is actually probably that. That is phase 3.
I don't know what that is. We're pointing at things. If you can.
499.
499.
Is phase 3.
And so again, is there anything that or are the parties contending that we should show them in response to this request? Let me just start with the state.
I can get a thumb drive. Let me go right now.
Sorry, Your Honor, could repeat, I was speaking.
So we've decided that there's nothing responsive that we can give them that answers James Jones Google search history. So I've moved on to part 2, which is geofencing, Google Phase 3 data spreadsheet. That's what they've also just listed here. So is there anything in the state's belief is responsive to that we can show them in some capacity?
Well, that would have been Exhibit 499.
All right.
Those are the complete Google records that we submitted that we received.
All right. So then that takes us to item 3, Christina Servidio's DNA reports, and it has parentheses 6. And so, do we have exhibit numbers for that?
And Your Honor, we didn't send them back because they are continuing with.
Can I, if I could just get a copy of those, I didn't see them.
This is defendants in there.
Okay. Is there not a state exhibit?
It was defendants 11. It was not a state exhibit.
Just trying to make sure they're.
It was not introduced by the state.
All right. Is that?
Um,
So it said it had a parentheses 6, so I'm not quite sure what that means.
It's the 6th report.
The 6th report.
I'm assuming what they're saying is the 6th report.
Okay, and that's Defense Exhibit 11.
Yes.
Okay. And so the position of the defense is that this should not go back because it's continuing witness.
Correct, Your Honor.
All right. What's the position of the state to that?
I agree with that, Judge. The report was never intended to be, even if we had entered it, it would just be for appeal purposes if there were conviction. I would never expect the report itself with her opinions to go back with the jury.
All right. So then, again, I'll just say when I see the word geofencing, I'm thinking the last note or 2 notes ago where they talked about maps is what they're talking about. So, and it seemed like the parties had been saying they can look at the maps, but in redacted form.
So it was the map. That's the best I think we can give them.
And so what is this that I've got?
It is portion of Exhibit 498.
498. Okay. This is with the language redacted, and is the position of the state that I then send this back or not?
Well, that would be what I would prefer, especially if the defense is agreeable with that, handling in that manner, then I don't think there would be any issues.
All right, let me hand defendant's 11 back. And then what say the defense?
I have no real objections to that going back.
All right, how about I'll mark this as since it's not a duplicate, it's different. I'll mark this as a court's exhibit. If that is agreeable, I'll make this court's exhibit 6. And so I can give them court's exhibit 6, but as to the rest of this note, I guess I should write on here, as to the remainder of your requests, you should rely on your memory of the evidence as presented. Any suggestions as to alternative wording?
I think that's appropriate wording for the court, Your Honor.
Collective recollection.
I like that one. All right, so if anyone wants to come inspect, I've got it written at the bottom. For your requests that remain unanswered, you should rely on your collective recollection as the jury. And I'll place that on top of Court's Exhibit 6, and I'll send that back with Deputy Scott.
Thank you.
All right, anything further, any objection on behalf of the state?
No, Your Honor.
Any on behalf of the defense? Then we will return to recess and off the record and await further direction from the jury.
You were on the run.
Wait, you would think that. We ran out of witnesses today.
And the judge just said, of course, state, pat, pat, patty, patty, ratty, ratty, patty, patty, wet.
Yeah. Not so much of that because I'm here now, but I think mostly it was just that it's the weekend and that's all. Well, she kept you 2 hours. That's true. I'm getting my time back from on that. What do you mean? Well, for her, we were here till then, so. No. I got half an hour back yesterday.
Okay. This is ridiculous.
I don't understand. I think what's happening is. I really don't know. I don't know why they intended to put most of the people on the list.
Blah, 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 get this.
So.
That's before no talk.
That's not gonna be no effect. In fact,
Nice.
but on something really.
No, we've, and by we, I mean, we bought the Toyota protection, right? So, all right, thank you.
That was a ticket.
Yeah.
With that redacted.
So anyways, they had other questions about wanting to see it.
Sure. Yes.
So.
I met him before you actually. But you just see more of me.
Met Danielle. She's in for a couple days.
Oh, this is an empty one?
Yeah. That's what you needed, right?
Yeah.
No, you just start pulling stuff.
And I've seen other people on her films.
How would you know?
That's a great question.
Go ahead,
Yeah,
Cameron.
okay,
Tell me.
choose your words
Ask-
carefully, Cameron.
Answer the question, Cameron.
I'm sitting right here.
Yeah, the joke that I would make is that because I'm work from home and other stuff, like really don't know who's in our office anymore. Like I started here and come from a different office where you may not know where, but I was like COVID had.
Yeah, I know.
It was very focused on the Atlanta area.
Yeah.
As viruses tend to be defined by geographical borders.
Yes. Yes. So, yeah, anyways, so, we're in a circuit where we
Trying to
have.
do Brian's job now.
Yeah, no.
I remember when they put a chair in front of the front lobby, except they gave them this chair, they.
Yeah.
Keep the germs away.
You can't get
In front of the front lobby door when somebody came in.
The germ door, yeah.
So many times.
I appreciate you.
Yeah. Yeah, I've never tested positive. And
I've
tested,
seen it.
and I have tested, but I've also vaccinated like.
I've gotten every vaccine the minute I could. I stayed at home for 10 years. I've had it 4 times.
Yeah, kid.
I know they grew up. That's true. Your baby was after COVID. Yeah, no, the minute my kids went back to school and daycare, it was like every few months. Horrible.
It's but anyways, so I say that as I came from an office where all my coworkers were around all the time, doing this office where all my coworkers were Jason Hayes. Oh yeah, Tasty Hayes. There's a man named Nathan who the year 2020. In 2019, he got divorced.
Yeah, that's the deal.
His wife left him for another woman, which happens, right?
Relatable, honestly.
It happens.
Just telling him that my husband's ex-wife is also a lesbian.
Yeah, it happens, right? And so that's
I love
not
that.
relevant in and of itself, except for he's like really into conservative, whatever, and like this 2020 where there's another election coming on and people are.
We know that's- We know that's
just a justice position between his personal life, which I and so.
I mean, be careful. I know already that you play golf, so you're on thin ice.
But I, listen, I know.
Here's an ultimate credit. You got one goal.
There's also.
Good lord, I don't know if it's helping. All
I
right,
can
it's
take
fine.
messages, okay? I'm a municipal, I have a membership with the city of Atlanta, like as well. And, but anyway, so. He is hot circuit, which that circuit at one time, that he was private, he would take cases that were appointed to him. Because we didn't have a conflict office the way that. Most circuits in Georgia don't or didn't.
I live in Gwinnett. We don't even have a public defender's office.
Yeah, okay. So, so you may or may not be aware that increases the variance of the quality of representation.
We were just talking about this. Yes.
That's one way to put it.
So he's, I'll let you,
He asked me why I come all the way down to Fulton from where I am, and I'm like, because the options where I am are concerning.
Yeah, so you can imagine that this guy, maybe what his standard of representation might be. And so he's like, but you know what I'm gonna do? Is I'm gonna fix the circuit. Run for Diaz. And I'm gonna challenge the incumbent in a primary as a Republican, because he's more, than she is. He spends what I'm to understand is a tremendous amount of personal finance, like his nest egg, office of boondoggle and does not win out of that. And so continues to be employed, but like while he's around primary season, around COVID, all stuff's happening at the same time. He goes to some church service that is in County, Georgia, I think is where that church was, where there was like the big, like first whatever, and people died. It was a revival.
I'm almost done with this.
Yeah, step out.
He was interviewed on
The one that he's going.
back in the apparently back to the other people. And he got interviewed by the local news. Because there's like a.
Because then I can't put the other thing on there.
Sorry.
That will print out with the.
Yeah.
Okay. Well, I think everything that can't go on.
No, what about these two PDFs?
See,
Use the word himself, but those were two facts.
it's got
Yeah,
the search
that's the
warrant,
word.
so it can, some of that in there can, but, and then this one.
They never.
You keep
know.
up. Can.
Look through.
No, I've got a Google alert.
See, that's what I was telling you, there are links in here
I know.
that we can't access.
And tasty. So he and I and another attorney tried.
That's a part of the file.
Case.
That's
right, that's part of that
Can you black out certain pages? Or can we print them out?
Well, I mean, this
Can we
is,
print this out and then black the pages we can't use? Does
yeah,
that make sense?
yeah, do that.
All right,
Because
go ahead and print it.
See, even this is,
Go ahead and
that's
print
the
it.
record itself. Okay, I'll print it out, I'll bring it
Yeah,
right
try to miss them.
No, I'll bring it. I'll get it.
I would like to do some work. I'm just kidding, you can,
No, let me do it.
1 of 18.
Yeah,
Well,
just
then
print it
I'm
all.
printing, you have to take my ID too.
Which
Yeah, just print all of it.
obviously.
That's before.
Yeah.
You got a life eligible
Rachel
15
something
year
or
old.
other does this in our office.
And also.
True. I swear I'll come back.
I don't believe.
Yeah, your client was
Right, my client
Yeah.
was party to for some other reasons, but.
just kind of there.
Allegedly.
Yeah.
He ended up getting.
It's- There it is right there.
We should all get t-shirts that say allegedly, just wear them all.
Wow.
Real cute.
Actually, yeah, it's a shower.
Think about the next one.
Yeah, I was gonna say something that's.
Yeah.
But you.
It's like a blank file folder.
He doesn't have.
Who has an open?
I mean, I think that's it.
Yeah.
I don't see.
He doesn't have
Unless
a
you can't
You have a
fix it.
copy of.
No. I mean, you can print out whatever you want to. I'm gonna bring it back and just pull it out.
Like the cover sheet. And it was only notes on the back of the cover sheet.
Because he's got.
I think we did
Priscilla,
a
this
release,
is a good example of the kind of.
Don't say that, don't.
But that.
Yeah, just put all that.
Nah, but that's.
Fair point.
Oh, you talking about just printing it out?
Yeah, just print it out.
Okay, I'm gonna just.
Look
take
at
this.
these lovely angels.
Yeah.
Instead.
Did you send it to the printer?
Step one.
Do you have anything else?
I could open this up and say, let me see.
Not say something.
That's what I heard.
Because
Okay.
the ballistic report.
This is it.
Oh,
Just print this up.
Okay.
Yeah.
Because what happened is there were multiple guns and like projectiles, casings, everything got matched up in certain ways. Puts the bullet that got fired into the dead person.
Yeah, yeah.
Very relevant.
Just say.
Yeah. Yeah, that's supposed to be.
It's begging me to like, just don't have anything yet, because I don't know, and I'm just like. I mean, I can kind of shape this, but like, not something bigger, you're fine, but like.
I'm not doing that.
But also like, why didn't you? Yeah, the client of the child.
It's been pending for a while, right? But this case was.
It was I think it was 18.
Yeah.
2
2 years.
Indictment,
Yeah,
yeah.
yeah. It was only, it was.
And it would have got a trial sooner, but we were in emergency for a long time. So this is November. This is when we're between peaks, and so the due diligence emergency is off, but ends up coming back on very shortly thereafter.
Yeah.
I picked a jury in James Brown Arena in Augusta, which is like the municipal one court. So they had people sat out like, for all mics and we're trying, face masks where you can see.
I remember those, yeah, they were talking about those in Coweta at the time.
And, it didn't matter what you did, they always followed up, so it's just like a pop on like, or the mouth that they see. So it's whatever that.
They should have done the thing with like the Google glasses, or not, the Apple
Yeah.
VR set where it shows a picture of your eye.
The jurors during court here would wear masks and then come up to the thing and then switch out for like what looks like a plastic welder's visor.
Yes, I remember.
Yeah,
What a
the
time in history when everybody was deciding what kind of mask they were gonna wear. I forgot about that. We had
I thought it was
visors.
fun, yeah, as an
We had like
accessory.
people in full filtered gas masks. We had people wearing
I love somebody walking
shopping
around with
bags
surgical
around
gear.
their faces. Everybody wearing the same pair of gloves all day long, as though that would make a difference.
Yeah.
Good times.
Did he fill up with like some huge stain?
Oh, let me, so he basically graphs off of his 90 days, like the lead in this kind of thing, which like, oh, whatever, like, one of the guys, they really didn't have anything.
Yeah.
They really didn't have anything.
Was that the guy that wasn't even there or something? Like, wasn't it?
Yeah, he was there, but they didn't have like any, he was just there.
He was there, it was merely present.
He was merely present.
Yeah.
So his attorney made it very wise. He showed up. And so he just showed up all the time and that great. His client also quit.
Yeah.
Love that for them.
My client's getting in a tussle with another guy while the stuff's going off, whatever. He's the adult, because one of the child found there was like a 17-year-old.
Still a child, but
Barely,
yeah.
Legally adult.
barely legally. And yeah, so the other guy is just like, you know, what, that's over, there's a big work. So we guys are like, before closing, there's like some break in the day, we get our conference. Well, lunch, he gets Arby's, and he's wearing.
I can already see where this is going. You can't just get
Can't
art,
you-
you can't get art and
You never talked about
it's
it.
so dangerous.
Can you see where this is going? Could you see that he was wearing a white tie?
Okay, first, I'm sorry,
Wasn't white
first of
for
all,
long.
what's a white tie?
Preachers.
That's a weird choice.
Preacher.
Like, yeah,
No, that's-
like
That's
mega
what I'm
church,
saying,
like
no,
preachers.
That's a fantastic comparison.
Yeah.
No, that's what I'm saying, like, well, you see that at church, that's
Yeah.
weird.
So what he proceeds to do is you get big old sloppy glob of like cheddar and barbecue sauce
Perfect.
on his white tie.
This isn't helping them, because we were already discussing that I want a sandwich really bad, so.
I mean, there's nothing wrong with
But I'm
it.
wearing a white shirt, I can't.
There's nothing wrong with sandwiches.
You can't.
Yeah.
My dude, I don't trust myself.
Maybe he did like one of these and like,
Oh.
projectile.
Maybe. Yeah.
Sloppy Arby's.
Oh, shucks.
Korean Times, take two.
So he gets to go, he goes second or third, ever again. And his.
You with me?
Yeah.
I was like, what?
No, but he proceeds to do church service.
Oh, good.
He does the Linwood. You watch that?
It was in this
Yeah.
courtroom.
Yeah.
So I caught a little bit of it.
Oh,
Yeah.
it's incredible.
It was a lot of money.
Yeah.
That's a lot.
Yeah.
I've been billboard that.
Yeah. Also, for now, it's like put it out, I guess.
Yeah, I don't like
Yeah.
it. Yeah, well, it's like getting line.
Yeah, good line. Anyways, it's still Linwood. He represents. What's the name of the guy from Centennial? Get the name of it about these people.
From what name?
The Centennial, I think.
Oh, yeah.
He had a serial killer name.
Some with a B. I thought. I forgot.
I have all the knowledge of humanity. It's not just.
It's the guy that was accused of the Centennial Olympic, like, bombing thing. It was like a security guard or something.
No, yeah, he,
Remember the time.
Richard Jewell.
Richard
Yeah.
Jewell, Richard Jewell,
Thank
that's
you.
what it was.
I had to use that case for for my appellate brief thingy for school, because we did a thing on my.
Yeah.
Blah, 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 blah. And that was, it was the AJC tool or whatever.
Mhm.
Yeah, I remember that case. That's fun.
See how that is put in there.
I didn't even know we had a movie about this.
Is it a movie or was it a limited series or something?
It was a movie, it was like.
Okay.
Hmm.
I thought it might have been like American Crimes, but no, I'm thinking about OJ.
And, saying this, if you ever watch the movie, you're like, oh, Sam Rockwell, it seems like that guy's doing a good job. I wrote in that whatever you see on YouTube, it's mostly art, where he's talking about how to been saved, and he compares the plaintiff's counsel to snakes and the devil and stuff.
I mean, know your audience, I guess.
Is that what you're gonna do?
He's thinking about it.
There's no bad ideas.
For your case. Well,
There's no bad ideas. There's no bad ideas except for like, anyways, we'll talk about it.
There's a lot of bad ideas.
There's a lot of bad ideas.
hey, where you got your haircut?
There is a guy named Aaron. It's near, between Old Fourth Ward and, I'm trying to think of the name of it, it just sounds better.
So you
Do a
didn't
good job,
know.
it's hard haircut. My husband's just like that, like me curly.
Yeah, it's like wavy and does
Yeah.
stuff in the humidity, and so, yeah,
Did you do no witnesses for something?
we did a few.
Yeah, they came around 3, so.
Yeah, we did the doctor who pronounced the child dead.
Oh, God.
We did.
That must have been fun.
It was not much for me to do.
Yeah. All right.
So, no, we did the crimes of that. And then we had a brief conversation about, outside the presence of the jury about like, so why do you need 6 photos of the girl after she's been pronounced dead, sitting there naked and hooked up to a bunch of stuff? So the judge to her credit is going to keep, she's gonna let some of it in, but it's gonna be heavily redacted and just.
Gee,
Okay.
isn't that a little better than what we had with that other case?
I think that she maybe has a different, I think, well, the other thing is like, this wasn't even for the medical examiner, this was just the crime scene tech after the fact. So it's just, because Travis was like, well, it's a murder case, we haven't proven she's dead, just like.
Gee, I think
Yeah.
everybody noticed.
Yeah.
So what do you think my defense is?
She's right there.
Lazarus come, like.
They use.
Yeah. Come out and break up.
I call, what's her name, Precious?
Treasure.
Sorry, Treasure.
Oh my God.
Treasure.
Judge, can we sound for this witness?
Had her under subpoena.
They're close to material with the form. Oh my God.
Yeah, so not my defense, so.
But that's probably for the best. I think you thought that one through. Seems like solid lawyer.
What they taught us at TIP, which you're not going to, if you're not. But TIP is the new thing for new attorneys, but they had some guy.
What?
They might send internship, so I don't know.
They're all going to TIP, you know?
I don't even know.
Are you
what
going to
that is.
conference?
I don't know what you're saying.
The
Going
summer,
to the summer conference. Are you going to the summer conference?
I also don't know.
probably not.
Okay, well,
They
then probably not.
sent me a list of like field trips I was supposed to
When,
go on. but
when
I
was
haven't
the
gone.
summer conference?
Third week of July.
Yeah.
Third week of July.
When?
Athens.
Sorry?
Athens.
Um,
Not Greece.
I've never gone.
You should.
One of the main
It's all your
things
CLE.
with
It covers all of them.
I don't
closing,
like the
right,
need
and
CLE.
developing your theory of the
Really?
cases.
I'm
Finding out what
seven.
you're
Oh,
factoring on
whoa.
the jar
Happy
and
birthday.
incorporating them into the theory of the case.
You know, I know.
I mean,
like-
like.
Yeah, no, I know
like-
when's the turn. I just didn't realize, because I know you were talking last year that you needed some.
Yeah, I was in trouble last
Maybe,
year.
yes.
Yeah.
But you know what? Look, I bet the conference is great too.
Yeah, no, the conferences.
It's probably fun.
That reminds me,
It is.
I'll need to send you guys an email at some point.
It's not what it
I
used to be.
am going to a conference at the end of this month. I'll just be done on one Friday. It's the
Denied.
29th, I think. I'm already paying for it.
Denied.
What is the company?
People's Parity Project.
Listen, what will we pay you for?
Conference in- Yeah, right.
You don't
In
shut up.
DC. I was on the board of our chapter last year, so I'm going this year.
What?
Which would be pretty
Is the
cool.
American Constitution Society still around?
I was the treasurer this year, so I would say yes.
I already started it. We can't.
Where'd you guys go? Yeah, yeah, PvP and ACS kind of like did everything together last year. And then I've done 3 rounds of treasurer now. I was a treasurer last year, ACS this year, and next year I'm the SK treasurer. I have run for 0. I get put into the treasurer position when nobody else runs because I did half of a good job one time and screwed myself forever.
What's that treasurer for? Pila? Yeah. Treasurer for Pila. Or something, no, secretary.
I'm in here.
I
I
don't know
haven't
what
done
it
that much
is.
stuff. I went to like the auction, but I haven't done that much this year. All I know is that now I don't have my own cell because I have to be the student bar association.
You want to sell?
No, my.
We can arrange a cell for you.
Not a cell, a Zell. I don't want to Zell like the money sending app. They don't want me to sell. I probably deserve it, but.
Man, student
Like,
orders.
is that
Incidentally.
He's been making fun of me all day. Now you want to put me in jail. This is a very dangerous job. This is a dangerous job.
Incidentally, when Cam and I went to the jail on Sunday night, Janet Williams was in the process of being released.
There was.
Really? That she made her bond? That's
Yep.
so great. Oh, nice. That makes me happy.
I am so happy about it.
It's always nice to have a little joy in the morning or
God, I was
that,
happy
the
about
afternoon.
it. Damn.
It sure is. All right, well, good luck, y'all.
Be free.
Thank you.
Have a good weekend.
Try and get some ready.
Yeah. You know, I'm gonna go back out on
Go play 9 holes or whatever they say about golf.
Sunday.
Is that
Yeah,
how
I'm
you
gonna
say
go.
a golf?
No, you're
I don't
not.
know.
That's
I don't play blinds.
Yeah, see, he said it's a golf thing.
Isn't it going to be raining over the weekend?
Probably.
No, you're
So,
not.
I'm not, well, I'm not going, I'm not
It's a
going,
storm.
yeah, no, I'm going to the jail this fucking month.
Go play some golf at the gym.
Listen, if you want me to come and talk to you,
No, it's just like, hey, do you want to testify? If so, we'll talk
Yeah.
about it.
if you want me to talk to him, I'll come talk to him. I'll talk to him about his testimony, whatever you want, I will do it, let me know.
Well, maybe Monday, I don't know what the time difference will be between when they break and when it's gonna be available for the evening. Monday evening will be probably the last.
We're on Monday. Or they said by 2.
You think they're wrapping Monday?
No, they said that they're planning on wrapping. So theoretically, we could.
You're closing too. Yeah, that's what you used to do.
Do you, my clicker is in my desk.
Well, I have one. I went and got one for the last stuff.
Ah.
And sit there and click away to my heart's content.
So I must say it was great fun.
We have stuff, we do have stuff to argue about. It's mostly because I think the state has got a little bit too much dip on the chip.
Stay away.
Yeah.
Why?
Because,
Why?
because there is research on them that splits the jury's attention and they're not listening to you
Yeah.
while they're reading the PowerPoint.
Well, that's the thing is you can't put too much on the paper.
Right.
You have to like leave it.
If you're using one, it should be usually just purely visual or something that you're actually like pointing to and referencing.
Yeah.
I prefer a whiteboard or like those tearaway big Post-it pads where I can like draw stuff.
I would say mine's
I'm really bad.
I'm talking about like lines.
I said what I said.
Yeah, I'm not talking about art here.
I would say predominantly it's big, but to me, it's like, keep track of where I'm going. Cause I just felt.
Yeah.
It does, and frankly, that for me is the biggest benefit of the PowerPoint.
I'm not saying that people don't use them effectively. There are people who use them effectively. I can't do it. I cannot do it. I don't.
I still like the PowerPoint. Now, if you want to watch somebody who does a PowerPoint, you should have watched Megan's class.
Yeah, I saw the TV one. That was the best time. That's kind of.
That was amazing.
We'll go watch her in court one of these days.
Megan is very good. Our motions hearing though has been really reshaped. Not say I'm sad, because that ain't.
Oh, that's the one with the like.
About 42 pounds or so.
Yeah. Yeah, okay, all right. No, I remember. Okay. Well, have fun.
Yeah, I'm so thrilled with that melody. It's another one I'm looking for. Did I say I've only got 100?
You did.
I've got a lot more.
You did not say that. You said you couldn't count them.
They're all wonderful.
Sound like, I mean, that number is set to be the way, because a case like this is equal to a case. More, that are just like, you're running the middle, whatever, possession wouldn't have aggravated, or whatever.
Yeah.
Like this is somebody.
Yeah.
And I've got I've got vitamins and oh yeah. And I've got the genuine brown. I've got two cases in. I'm thinking of talking to one.
They finished, what's it called?
Raylan Brown.
That's the one. Who, did Richard try it?
Richard tried it.
I got surprised with Raylan's.
And I think he'd be happy.
Oh, he did? Okay, that's good. He hated Richard. I mean, he hated everybody, but. No, Richard, I mean, Richard gets along with everybody, but like, Raylan Browning did not get along with Richard.
I don't know. Managers. Stocks there.
Yeah.
I mean, absolutely. Stocks there in banana.
It's one of those things where you like hear him talk and you're immediately like.
Brand new term. Love that.
He walked up behind female attorney crossing the road in Midtown and shot her in the head.
That's awesome.
I don't believe he knew her from a bar of silly soap.
You have a real gift for descriptive language.
Everybody shot her and ran away.
That really is.
He was arrested. I think the same evening with the gun in the car. Of course, he says he doesn't want to. Doesn't have nothing that he can respond to. Because he doesn't know. So the idiot that he goes off to talk to. And I'm trying to get from some sense of what's going on.
You've really been gifted with the active finance.
Yes. So I said it in, you don't know because you was there. But when you were arrested, there was a gun. Can you tell?
Oh, y'all gotta go too. Y'all gotta go too.
No.
Turn.
He wanted to criticize the indictment, and we went through this whole thing. The indictment is defective. It wasn't signed by the law.
It was not returned at the time.
He said it wasn't signed by the law. Explain taking the gift. The charge.
Wait.
It's always nice.
He go all like a dog. He can't like a dog. Here, he said, walk like a duck, look like a duck, act like a duck, listen to the same.
I committed felony murder and
He's rolling in court.
predicated on,
Almost like that's how felony murder works.
and I went on it to explain to him. Anyway, that was and the charge, at the day he was booked into the jail, but he's all so bad. He bit into his vein and into his hospital. They say he's perfectly competent.
Do you know, that's like very hard to do. Most people's brains don't let them train themselves. It's like a whole thing. Yeah, that's kind of indicative of someone.
They found him.
Oh, good.
Because they said he would discuss.
And you didn't call the police? I thought you should at least help her. The girl said, well, not my business. He said, but the girl didn't testify.
Yeah.
But it's so cool.
You're
gonna ask a poacher.
So the court goes to see.
He said something. He said.
He was.
He will convince you to.
And she found him coming to Georgia, but Georgia says number 30.
Yeah, he got called, yeah, he got called every time. He called every time. The cycle's over. Back in here again.
Sounds like it.
There you
Yeah. Take it at their surgery.
That's why I told you, I did not leave that on Wednesday. I was like, you know what? I've been in enough mental hospitals, none of them are great. And I'm good, they don't. I will eventually, I'm sure, but it is a little guilt trip, and I was like, I'll go try. Yeah. They're always.
Well, no, I think that goes. Okay.
All they do is like throw people.
Yeah, the
on
email.
Zoom and get their sites for 3 months and hope that that feels like right.
There we go. Good.
Imagine that. There we go.
All this is being broadcast on YouTube, by the way. So,
Oh, no.
Let's see. I saw it referenced.
Oh, okay, so there.
Ours might be
Version two.
I got my hand note on there.
Yeah, that's true, but is that really
My
a,
hand note that says Google.
yeah,
Thank you,
I
Christina.
mean, that could be, we can get
Oh,
rid
got
of
a little handlebar voice there. You got a hand. Should I have gotten rid of it?
it. I mean, this one's the easiest one to just pop. Right there.
Oh,
You want me to get rid of it?
440,
Yeah.
What's that?
Yeah, I would just say,
Oh, do you want me to get rid of 1095 as well? Fix this real quick. Just get it out there, knock it out.
They usually don't.
I thought it matched the break in the morning. Oh, wow. It sounds like a whole lot of practice.
yeah, everything came back and I picked up, so. Well, I mean, it may have I think it's a link to the, but the links on here that I get from her goes that I'm back in.
But it's sticky.
No, one of them at 5.
Separate isolated piece. This is the stack. Flip it over. See, because I mean, there's some coordinates here. Coordinates here that would have been what you could plot something with, you know what I'm saying? So, and this is 1 a.m. 2:13. So that's it. 1 to 3.
Probably next week.
Right, this is a printout. I have removed all of the search warrant affidavits. So I'm just gonna flip through here. So now this right here would be the actual ordinance. 1 a.m. to 3, so I think they should be able to get that, because that's the part of the thumb drive that was tuned in. And it shows the latitude and longitude, they're asking for.
And that's not based on a link, right? No, that's
This is the printout from the thumb drive.
actually on the thumb drive.
This is the printout from the thumb drive.
This is not the printout from the thumb.
I took the thumb drive evidence and printed
She did it typically after.
it just now.
This is the Google.
Yeah, that's what they're asking for. That's the Google location information
This is the Google location information.
that I just printed out from the thumb drive that we entered in evidence.
And I handed in, Evidence 30 was the Google location information from, it was like this.
Okay.
Um,
So that's it.
actually, no, this is like 31.
Okay.
This is like 31.
They already have this.
Yeah, they have,
Okay,
Okay, well, there you go.
they don't know they have it yet, I guess, right?
they
Well,
do.
That's for them to look through.
Okay.
31.
Yeah, if they have it back there.
I don't remember you tendered, I know you
Yeah.
tendered some latitude and
No,
longitude.
she did,
That's-
because she crossed Brian on it.
Oh, okay.
Yeah, that was a pivotal moment in Brian's cross. I think.
Let me show you one. Actually, no,
Was this a different printout?
this is,
Yes, the printout.
Okay.
because it's,
It's his phone, latitude,
oh,
longitude from
this
1 to
is
3.
phase one.
No, that, I think that's,
This somebody has.
no, this is phase 3. This is showing his location information.
This is definitely not phase three. It's not phase 3 in a million years. Because it only goes up to 340.
That's the time frame they were looking for.
But that's,
Well, they said phase 3, then it said time.
But no, the time
But
frame was looking
phase
for
two-
a specific period of time, 1 to 314. That's what's reflected there.
you need to look at your documents. Phase 2 shows already an hour each side of this.
Okay.
And that's what I handed in.
But they haven't seen that, or that's an
It's the
addition.
same thing.
Okay, all right,
It's
so
the same thing.
so we're talking about them having location information and that's it, and that's just it.
That's, I guess what they have is inclusive of this.
Okay.
Yeah.
Do you want this back?
this?
You want this back?
Sure.
Thanks.
All right.
That's right. You saw the salary, right? You should.
Phase 2 goes on. Has the additional thing at 5:30.
But did you see the salary? That's what we need. Where is it? I was not my best at Troy. Get your bachelor's degree? I won. What, it was called Troy State University. It was a Troy University. Well,
It's like stuff out there, like, I heard every day that thing.
I know. That's what he had done. He's short, he's more than short. Yeah. Crop, sure. What you say, crop?
It really was, that's what I said, it can go to black and white. Yeah, what I said.
We had talked to the jury. See, I would think this
I shop at Kroger. I shop everywhere. Walmart, stop shopping at Target. I don't shop there no more. I shop at Target. I ain't never shop at
fresh meats.
Never get it.
They don't even know where to be there. It's not that many. To work out. You got it on them. Well, that was something parks. Okay. Cause they make it round.
Today's better than the last one because I've been pretty off somewhere.
I cut the heels. I'm still looks different.
Last longer than everybody ever tried.
Actually, all those cases that.
Right.
Crocs, yeah.
Bring them over and
They don't make it my size, that's 13, they don't make Crocs.
Oh, yeah, they do. They make them as high as 7. Yeah.
They Crocs, where'd you want that, go to cluster them, go, they got the other, I got Crocs.
All right, thanks for your stuff.
Yeah, if they had come to shoot, you was coming up like that, they had come to shoot. Now, some of the joints like them joints, they got no hand. The joint back in the day, they would crumb the good ball. But they ball it now, I'm like, man, they ain't gonna last longer than we got. We ain't got no kind of room where to shoot it. You don't know what people say, so y'all say brothers.
Hey, that's big.
The ones you fight with?
Yeah.
With the key, the line key, we put them together, you had the tennis shoes.
My
Tennis
dad and my
shoes,
grandma.
tennis shoes,
I see his hair. Yeah, and my grandma.
What's the mistake? We had 4 mistakes.
I like it's like Gwinnett County Pool and it's like the fenced aquatic center or whatever, and it rocks indoors.
I don't do, I was so weird. Like that.
What's the 57? I don't know whether they would have been for that picture. Oh, yeah. Oh, man.
If there's anybody else in here,
I ain't even jam. I ain't even, that's the deal. He mastered that himself.
Right. You're just make that. See that on like, oh yeah, that's not letting you learn back in the day either. I was called my dad said, you know.
That's why they put the 70 band. It's on the side of the wall. You tap it. If you say you tap it right there, look it up.
Dave here.
I didn't know if it's yeah, it's okay. You
Can you hear me, Dad?
Oh, I was never this in small. Never do it.
Yeah. You know what the 57 on the ketchup bottle means?
Yeah, we'll go ahead.
Yeah, you know what the 57 mean on the ketchup bottle?
Hopefully they.
What it mean? See, I told you. That's all the stuff you know. The sheriff's in here playing talking about the 57, tap the 57 on the bottom and then ketchup come out, right? That's how you feel about it.
No, look it up. Look it up on the phone.
Yeah, I just remember every time yeah, they said we didn't reach it. Oh, my goodness. This is one thing. My sister. Still at work. Yeah, he said, I mean, so.
It's fine, we're all being spied on. It's very important.
So cool. My dad, you know, my dad's worth 69. Like, I say you the excuse.
I mean, it's on there, but it's not the only thing that they have on.
You exaggerated? I thought that was weird. Say, okay. All right, he says he goes. See, I was saying, you can't. All right, you can't shoot. What is that? Say when I get. What is it? It's 10. Yeah, my dad said he don't know what they talking about. Yeah, 5+7 equals 2. Got catch up.
What else?
What are some flowers?
Yeah, forest supervisor, 3 is.
No, force not to supervise.
It's not necessarily supervisor, generally supervisor.
Force not to supervise.
But it's the most senior. Attorney requires the most experience. 3 is, like senior trial attorney. I don't know.
Still.
2 is like complex trial attorney. I think 2 is like 5 years. 3 is, I think 4 is.
No, you said it's happening. I was like, what was it said? And when I said it's 7 yet.
Okay, so take out, that's what I. Yeah, it's too late. I can write 25 things.
We can help, yeah, bring us something.
I know, it's the outfit. I don't think you're in that big.
Yeah. Listen, I know that's what you just brought me. I know. I know. I know. This is ridiculous. All right, so I already gave you one of those, didn't I?
Yeah, just gave me that one.
I was looking for it all over the office. I'm like,
Oh, yeah, I thought, well, yeah, it was just the redaction. We've been running all day though.
those are extra.
That's it.
We didn't give it to him.
Hmm.
You haven't given it to him yet?
I showed it to him, yeah. I think there's some confusion as to which phase that is, but that is, she thought she had phase 2 that she submitted.
Yeah, but phase 1 is the bond test. And then part of phase 1 is her maps of him walking. Phase 2 is who he is. Yeah, and phase 3 is the search. The extended area. It gets confusing. Oh, no, man.
So then this is the second part, but it's the location data that are there.
That's the location. Right. Oh, this
Check my bank account.
If they look at this. That's hitting. Mm-hmm.
Just let me get it. It's Friday, so it's not really shy.
Should I just get a copy of this?
Pick up food things. I usually try to get something on my way.
We'll see what time.
That's what I was concerned about right there.
Oh, yeah, yeah. Yeah, that's what, yes.
You know, I'll go to it real quick.
My daughter to this, and our dog to the splash pad today. He's home on Fridays, so we kept him fun. And they've been playing at the splash pad all day, and it looks really cute and fun. But he wants me to pick up food on my way home. I'm trying to decide what to get. I was thinking like some like deli sandwiches, like big sandwiches, but now I'm thinking maybe pizza, because we haven't had any in that time. I want like good pizza, you know? I want some like arugula and caramelized onions involved. I can't decide. We used to have around here, well, I guess it's more like Decatur. It was can't remember, they just shut down and it's in my entire city. There is one place near me that's like pretty decent, but I don't know, we honestly don't get pizza a lot, so I don't, but for some reason it's sounding good right now.
That's why they gave food. Yeah, so they can close it down right now, so. People, you know. I did my slot. They need to go. That's why, you know, any organization, nonprofit organization, but they will put it.
They doesn't look
Five? I've never seen him keep people long past 5. He doesn't go till 10 like other trips.
So it don't be, you got
Like certain other.
Maybe I will do it Monday. That'd be crazy. I was waiting for a long time to find out how long it was.
I'm saying.
Yeah, you're near. You go south, right down, so that road then goes down from that, Macon, cuts kind of southeast.
Electro.
Take this over to.
You basically make the poker hand and try to get.
So who's in?
So, play your hand.
That's serious, that's right.
Okay, well, like everybody else, that. They like to race.
That's a nightmare. I'm glad.
Right. It's not very.
Here's this one,
Everything.
which I think is kind of that one. Until it's right.
Honestly, pretty just. It's. It's
on that.
You started.
I don't know, I mean, then. I don't know. Did we know? I've been running back and forth. Okay.
They have a little storyline, but then it's also just sort of a compilation of many things, but it's really cute. And like has distinctly anti-capitalist vibes, which I
What we doing about it? Look, we doing about
You have to like collect different little uniforms, it's like different disguises, so you can go places, they catch you with Sasquatch, the park rangers. It was on like the, whatever the Apple arcade thingy is, so it was free, like for some reason I'm still paying for that. Apple.
Yeah.
Yeah, one off this guy, we got a lot of. Except the road still about it, so they got up for us. He came in here, he got a job, so he's. He got he's peon and farming rules, all this. He had a little beat, we was going out. As we doing the Trump thing. And then he was beating all. He comes fucking trying to get you. All the farmers, you know, so we're gonna have to go to our. You want to go to our age.
Yeah. Expect things out of you, but you know you're not capable of doing. I can't do it. I'm sure I would have to ride the word. Oh. Just show up at work. Oh, just shoot me now. Just please. And then grandma walks up. I knew not to work at big. No, but I'm gonna call it big now. You got a new word? Big, yeah.
And I have a monster truck, the lift kit on.
You guys.
So.
$4 and $45. I'm going to get my change back. It's $5. It's not $1 for water, for bottle of water. You know what people want to say?
Is that
They can come club, and they kind of, license come over. Yes, unless there's somebody else. That's all. I gave one $5. Split it between them. He said, he gave those. You know. First quarter, go play up there. See the meeting, depends on what I'm on. Yeah. I think my man can. That's why I lost my bill. I do. Sure.
Yeah.
But he got the same ball. So when he changed over, I come up with that same ball. So I said that a Redwood and 12, no, he better than 75. Yeah, the little dude, we should think they take turns coming up. It's the same.
It's got to be.
Yeah. I mean, one guy, I mean, when I was in the county, yeah, we got, maybe, but if you keep going to that, maybe that station, that's it. Come on, there's one guy coming out. I said, you know, you want to look at these things, but I'm gonna look out back. You want. That would mean which I got one. Cause I have yet to try out one city.
Well, when we come over stuff, we always say that. Actually come for Sunday, it's like a lot of girls, take them to the aquarium.
Oh, yes.
My son works there. He's got 3 passes.
Oh, so you've been there already. Probably turned out.
In a way, I said graduated in 1977. He graduated, you know.
If I would say something. Yeah, that means well. Who would do it?
We have the attention behind the city. Attention variables. No.
So,
Virginia House is 200.
yeah,
Transport. But you can have 100 some people. Some of them. Okay, 40, you know, so anything. Certain time, we can.
for the day.
But they did the boiled egg and juice.
With what?
Missiles.
Okay.
Then they get out of jail. This.
Yeah, they have numbers there. They spoke. Chips.
It doesn't, it looks like they intercepted a lot, but they hit a lot, they hit some stuff too.
Hmm?
Iran just hit Tel Aviv and with missiles. So unfortunately, it looks like they went civilian on that one. Yes. But they've intercepted a lot of, most of them, it looks like a lot, not all.
Yeah, they come to intercept everything. Is America doing that?
Apparently lawmakers are currently divided. Surprise, surprise.
Shocked.
Yeah.
Oh, I know where they made it. Is the 13th that free?
Yeah, so it came over. It came over, where they go? I've been better before. I never seen this. My wife's stuff.
Tell them to come back Monday and resume the deliberations. Or two, I can give them a note and ask them how much longer they want to stay today. Any preference from the parties? Let's start with state.
Your Honor, I think it might, as I think it might be a better course of action to come back on Monday.
All right. Any input from the defense?
Objection might not be a bad idea to ask them if they would like to stay today.
All right. I'll do that. And I think I need a piece of paper and you have a notepad I can write on. Yeah. I got something I can enter for the record.
In the top drawer.
There you go. I'll mark this as Courts Exhibit 6, I believe we are on. So in terms of phrasing, just say how much longer would you like to continue deliberations today? We can break and resume Monday if you prefer.
Yes,
All right.
give them the option.
All right, so what I have written here is how much longer would you like to continue deliberating today? Question mark. We can break and resume Monday morning if you prefer. Well, if anyone wants to come inspect, they certainly can. Otherwise, I'll give it to Deputy Scott. Deputy Scott will show you before he takes it back.
Thank you, Juror. Thank you.
Well, there you go. Why don't we do this, Deputy Scott? If they have a note for us, let's start with that before you give them that. Okay? What's up? Okay. All right. They've written a response onto Court's Exhibit 6, and it says, we prefer to come back Monday. So with that, I'll tender Court's Exhibit 6 for the record. I'll bring them in, I'll excuse them, and we'll report back. I'll let them resume their deliberations at 9:30 on Monday as we take up some other business at 9 o'clock. You can bring in the jury. Give me a chef. Thank you, Deputy Scott. Please be seated, everyone. Members of the jury, we know that you've been working diligently, and we are appreciative of the effort you've put into this case so far. The indication I received from Deputy Scott is that you would like to and prefer to resume your deliberations on Monday. And so that's what we will do in this case. we'll plan to reconvene. You can go directly to the jury room, and we'll just set a start time as 9:30. And so you can get here earlier, but please do not resume your deliberations until all of you are present. And from there, we will await further direction from you. If anyone has anything they need to address, scheduling wise, you can let me know. But otherwise, we will see you back on Monday morning. And I'll remind you, please do not discuss the case with anyone, including amongst yourselves when you're away from each other. And don't do any research about this case or the issues involved in this case over the weekend. And with that, we'll see you Monday. Thank you. You have something to address? Just stay in the jury box. We'll pick it up. All right, we have one juror who stayed behind. Looks like she wants to discuss something. And ma'am, first, let me just, if I could have your jury number. This is juror 24. And what I want to say, first of all, is I don't want to hear anything about what's going on in the jury room. If you have some scheduling or logistical things you want to talk about, we can hear those. Is there any issues with from either party with proceeding with this? No. Okay. All right. Ma'am, what is it that you wanted to let us know about?
Truly, I'm waiting for my granddaughter to be born. I don't even know what's going on.
Okay.
Now, I went this morning with I want to know what's going on. I don't have to know, and I want to be there.
Okay. And so I understand. So you're in a situation where you have you potentially a granddaughter being born here in Atlanta.
So they in Connecticut. So I don't know if I will have to, I have no idea right now what's going on since my phone was out. I don't know if I will have to go Monday, meet them from airport back here. I have no idea what's going on.
Okay, well, certainly we're going to get you your phone back because we're done for the day. And so you're saying essentially you're letting us know something may come up Monday.
Focus on my family right now, so I'm not sure how they could be using decision.
All right. I want to focus on these issues. I certainly recognize that and that this is a very big time in your life. What is it on Monday that you think might come up that you need to be at?
So we have to meet them from airport if they, I don't know at this point. And second, about how I'm taking care of this with Oma. I'm here. I have no idea what's going on.
Well, coming into today, is it just up in the air? You just don't know?
Yeah.
All right.
I mean, you never know.
Exactly.
When baby is born, exact time.
But they'll be flying in with a baby on Monday, maybe, your family?
Yeah, what's going on? Is it born? Is it still? Do we have to meet them? Are they flying back? I have no idea what's going on at this. But my mind is not with the case. How, clear I will be on my decision to do anything. I don't know right now.
All right. So what I think we need to do is get a better understanding of what might happen Monday. So I think what I would ask you to do is when we come back Monday morning, before we get started, you can come out here and give us an update. You know, if you want to be here at about 9:15, you can come out here and give us an update of what's going on with your family. And if you think this conflict is still presenting itself, and if some emergency comes up over the weekend, again, I'm not quite sure the timing or regardless, the expectation is going to be, I would see you Monday morning, and then you can tell us more about what you've learned and what the situation is. So you're going to have your phone back and you'll have all weekend to kind of learn what's happening, right?
something, I cannot help. I know that they would have to be here.
But we don't know yet when they're arriving. Okay. So when we come back Monday, you can let me know if things have changed, if you've learned new things, if you think that's going to happen Monday, or maybe if it's already happened. All right? Okay. Any of the parties want to follow up? I think I've tried to get through this.
Nothing from the state, Your Honor.
All right, Ms. Levinsky.
Thank you, Your Honor. Juror number 34, 24. Thank you. Where is this child being born? Sorry?
Connecticut.
And it is being born to a surrogate.
Yeah.
And your son or daughter is going to pick up the baby. You say they're ready to leave?
They already left this morning.
They left this morning. Do you know whether there is a cesarean scheduled or anything of that nature?
You're, all right, I don't think that's,
Okay. All right, that's fine. We're just trying to understand exactly what's happening. And you're telling us you don't really know yet?
I don't know.
So
They flew out, something.
they flew out of Connecticut to come here?
No, they went to Connecticut. That's-
Okay, so they're in Connecticut right now. We just don't know when they're coming back. Okay.
And your mind is elsewhere. And your mind is elsewhere. And you realize how important this was.
All right, you don't need to answer that question. Ms. Levinsky, do you have anything else?
No, thank
All right. Thank you, Juror 24. At this point, we would expect you to see you back Monday morning, and we'll talk with you again, okay? All right, so let me start on this issue that has presented itself to us. Is there anything on behalf of the state?
Your Honor, I think while I think she should come back on Monday if she can, I think it would probably be that's why we have alternates in case she needs to leave. So it may be a reason to call the first alternate in for standby just to make sure they're here.
All right, Ms. Levinsky?
I think we should replace her with the first alternate because it sounds like her mind has gone from this trial to my mind is elsewhere. I really don't want to focus on this trial. I have no interest in being here. And unfortunately, a person's life is at issue. And I don't believe it's fair to have that situation where everybody is just not interested in focusing on the trial.
All right, so in that case, if the parties are in agreement in this suggestion, I show the first alternate as being Juror 27, who I think indicated she was a stay-at-home mom, so hopefully she'll be flexible. And I'll note, looks like we've got the statute that recognizes these sort of things come up. And so I'm looking at 15-12-172, which means even after final submission of the case to the jury, that a juror can be replaced upon good cause shown to the court that a juror is unable to perform their duty or is discharged for other legal cause. And so I think we've inquired of the juror on the record. It seems the parties are in agreement this juror is potentially unable to perform her duty. And if she's replaced, then Monday morning, I would then instruct the jury that they're to begin their deliberations anew. If 27, I think we'll reach out to 27 and start there. And I think that's the plan ahead. Anything else from the state?
No, Your Honor.
Anything from the defense?
Okay.
All right, if we're able to reach 27 by the end of today and confirm that she will be here Monday morning, I'll go ahead and also inform 24 that she's excused. Otherwise, I guess we'll see her Monday morning and address it and see what presents itself. So with that, we'll be in recess until Monday morning, until let's say 9:15.
Do we need to?
We're off the record.
15 minutes? 499 is.
$4.99. Please.
They go into evidence? Or should we just put them?
Well, I mean, I guess this is what, I want to see.
Right. Yep. So we haven't submitted.
Happy Father's Day to all the fathers.
Thank you.
Don't do absolutely nothing, just watch football or basketball.
Hey, it's US Open golf.
Okay,
I
watch
mean,
it.
that's Father's Day tradition. Yeah. Yeah.
Well, have a good day.
Actually, I think I'm playing golf.
I guess I'll just keep all this in here.
Yeah. Let's just put all this stuff.